Assalamu alaikum everyone. Greetings ladies and gentlemen. Good morning everyone. My name is Misbah Shahid. I am 4th year law student from Fatima University, and today it's a great pleasure and I am really privileged to stand for such an experienced gathering. And first of all, I would like to extend my warmest welcome to all of the worthy participants, to key organizers of today's session, especially Ms. Aish Farid Khan, Head of the Department of Law, Fatima University, and also the DG of Federal Judicial Academy as well. So as we are all gathered here for a session titled as Negotiation Mastery, Theory, Jurisprudence and Practice. And this session is co-organized by Fatima University and Federal Judicial Academy. And the resource person for today's session is esteemed Dr. Jo, who is Fulbright Specialist, and I'll be introducing her as well. But before that, let's formally commence today's session in the name of Allah subhanahu wa ta'ala, so that he can guide us throughout this learning procedure. For this, I would like to invite Mr. Hafiz Irfan Ahmed to please join us here for recitation of Holy Quran.
أعوذ بالله من الشيطان الرجيم بسم الله الرحمن الرحيم لله ما في السماوات وما في الأرض وإن تبدوا ما في أنفسكم أو تخفوه يحاسبكم به الله فيغفر لمن يشاء ويعذب من يشاء والله على كل شيء قدير صدق الله العظيم.
Jazakallah. So let's give an enthusiastic start to such an esteemed and insightful session. So I would like to request all of the esteemed participants and guests to please rise in respect of National Anthem of Pakistan. Thank you so much, everyone, for this representation of respect. I really acknowledge and appreciate it. Moving further, before inviting our key organizers to give welcome note and to welcome our esteemed participants, I would like to take a minute to introduce our resource person, Dr. Joe, because it would be a great honor for me. So, first of all, Dr. Joe Chitlik is an expert in negotiation and dispute resolution. She is a former UN lead negotiator to UN General Assembly and is a registered ADR expert as well. So currently she is serving as a Fulbright specialist, partnering with various host countries to conduct different programs. One of these notable collaboration was with our very own Department of Law, Fatima Women University, past few months, which ended with a number of fruitful outcomes. So if I take a minute to highlight her contributions in that program, so it would be like, first of all, there was an ADR course for all of the law students Padma Women University. And then there was a research engagement with 10 students of Padma Women University, out of which 3 were supposed to be selected for publication, and it is almost done. Further, there were some speaking engagements by Dr. Jo in different arbitral institutions and IBA, in which her aim was basically to promote ADR in Pakistan. And as we can see that she's doing great in it. Further, she also has served with her writing skills in the realm of ADR, and her main focus was on court-mandated mediation as well. So this marks her second tour to Pakistan. Again, her aim is to promote ADR in Pakistan. So she is an extreme expert in this phase. So I would like to request all of you to give a well-deserved round of applause to acknowledge the presence of such a great expert among all of us. Thank you so much. So now I would like to request the Director General, Federal Judicial Academy, Mr. Hayat Ali Shah, to please join us here and welcome our participants. Along with that, share with us your thoughts about this collaboration. Please welcome Mr. Hayat Ali Shah.
Alhamdulillah Rabbil Alameen wa salatu wa salam ala Muhammadin wa ala alihi wa sahbihi wa barik wa sallam. Joe Chitlik, Zahish Fareed Khan, Dean Faculty, Fatima Women University, learned lawyers, law students, professors, and my dear senior citizens from all over the country. It's a great honor for me to welcome you all here in this 2 days workshop on negotiations mastery. I'm especially thankful to Fatima University that they collaborated with us and gave us also an opportunity to listen and to hear the Fulbright scholar, Dr. Joe Chitlik, who is a known expert on negotiations. Negotiations is a way of alternate dispute resolution, and we have changed this term alternate dispute resolution after Honorable Justice Mansoor Ali Shah has, I will say that his thought is that it is not an alternate dispute resolution system, rather it is preferred dispute resolution system. So we call it now PDR, preferred dispute resolution system, preferred dispute resolution mechanism. So one of the steps or one of the ways of dispute resolution is negotiations. And it is not new in our culture or in our society. Particularly in Islamic State or in the Muslims. We are guided by teachings of Quran, and Quran has several times told its believers, and particularly the prophets, and particularly then the Holy Prophet Sallallahu Alaihi Wasallam, that negotiate, talk to the people, and has given the ways how to talk to the people. Quran sends Musa and Harun to Pharaoh and directs them to talk to him mildly. All this is negotiations. The best negotiation and the best result of negotiation is the first written constitution of the Islamic State of Medina, when it was negotiated between Jews and Muslims and Muhajirin and Ansar, and a constitution was drafted. That was the result of negotiation. Dispute of the agreement of Hudaybiyah. It's another very big example of dispute resolution. It was a big dispute, and they had to negotiate and settle it through Hudaybiyah agreement. And then above all, when Makkah was being conquered, and when everything was in the hands of the Holy Prophet and its companions, again the matter was settled through negotiations. The matter was negotiated, and a big bloodshed which was possible to come was avoided through negotiations, and the matter was settled peacefully. So negotiation, as Chatlik will be telling you, is of two types. One is dealing with the past disputes, and the other is for the future arrangements. So our history, our religion, and our culture has got numerous examples of both types of negotiations. Dispute resolution and future arrangements or bargaining, whatever you may call it. So I won't take much time. I'm thankful once again to Jo Chatlik that she is here, and we are eager to hear from her, and particularly majority, I think, is that of Honorable Senior Civil Judges. They are the people who are handling the courts, and of course your specialization is court annexed mediation or courts annexed negotiations, how they will be using their office for the purposes of negotiations. So thank you very much, and of course I welcome you all to this 2 days workshop. Thank you very much.
Thank you so much, Mr. Hayat Ali Shah, for your insightful words, and thank you for highlighting that Islam is the main source of all of these dispute resolution mechanisms, of course. So next, I would like to request Head of the Department of Law, Fatima Women University, Ms. Daish Farid Khan, who is another key organizer of today's session, to please come and welcome our participants and also give your insights about this collaboration. Please welcome Ms. Daish Farid Khan.
Assalamu alaikum. I warmly welcome all of you in this 2-day negotiation mastery course, which is jointly organized by the Department of Law, Fatima Women University, and the Honorable Federal Judicial Academy. The Department of Law at Fatima Women University was established in 2015, and since its inception till date, we are not just focusing over the academic excellence of our students, but we are deeply concerned to provide them maximum outreach, exposure, and practical learning to our female law students. And this cannot be done without an intensive and rigorous networking and collaboration with the legal fraternity. And today's event is an evidence to this, our efforts. If we talk about today's event, so this event has actually been developed under the auspices of Fulbright Specialist Project. We are truly honored to have Dr. Jo Chatlik as a Fulbright Specialist. She's executing her Fulbright Specialist for FSP project at the Department of Law, Fatima Jinnah Women University. This whole project was actually divided into 2 visits. Her first visit was taking place in the month of May, and this is her second visit at the department. Today it's a great moment for me to see a room full of legal professionals like judges, academicians, practitioners, and today all of you are sharing a common goal, that is to refine your negotiation skills and to adapt yourself to the evolving landscape of dispute resolution in Pakistan. And there is no doubt that in recent years we have witnessed a significant change from traditional litigation methods to ADR mechanism, alternate dispute resolution mechanism. And Pakistan is now embracing all of these alternatives, these valuable alternatives. And if we just talk about negotiation particularly, so I believe that a successful ADR practice is deeply embedded, deeply reflected in effective negotiation skills. So that is why in these 2 days, you all are going to learn about the theory, jurisprudence, and practical skills that are required for effective negotiation. We have divided this course in 2 days, and each of the day we have different sessions. Like today, you are going to have sessions over the fundamental of negotiations, Islamic principles of negotiation, and effective communication strategy or effective negotiation strategy. And tomorrow we are going to have sessions over the legal and ethical consideration and cross-cultural communication or negotiations. So as an organizer, I would like all of you to participate fully, share your experiences, and just take this course as a token of or a small step or a small, contribution at the part of the Fatima Jinnah Women University in this recent week of ADR in Pakistan. So once again, I welcome all of you. Thank you.
Thank you so much, Ms. Aishkari Khan, for sharing your invaluable thoughts, and we really appreciate this contribution to the arm of ADR. So here comes the time to invite the resource person, Dr. Joe Chitlik, because I am not going to take any more minutes, as it will be a wastage of time. So I'm going to hand over it to Dr. Joe, and I would like to request all of you to please welcome Dr. Joe Chitlik.
Good morning to everybody. Thank you so much. Salam alaikum. I am so unbelievably honored to be here today. I want to, before I even start, I want to thank the organizers. I want to thank this beautiful venue. This is absolutely gorgeous venue, prestigious Federal Judicial Academy. I appreciate you opening the doors to me and allowing me to teach about ADR and negotiations. I also want to thank my host institution, Fatima Jinnah Women's University, for the ongoing collaboration that I have had in Pakistan regarding the US Fulbright project. As anticipated, I am here in the past months, coming and going back to the United States. And the purpose of my trips have been to establish a pilot program in the University of Fatima Jinnah University. Now, we did not expect the type of greeting and embracing that we got at the time, and this has just exploded and has given us the additional venues to be able to bring today to you, all of you, the possibility of talking about ADR, one of my most favorite subjects. I am very honored to have here, first of all, I would like to acknowledge the judiciary, without which most of this is not possible. I want to thank each and every one of you for your daily cooperation, for your commitment to Pakistan, for your commitment to the rule of law, for the wonderful judgments that come out of your courts. Thank you so very much for that. And I would like to give an applaud to the judiciary. Thank you very much, Your Honors. I would also like to acknowledge my wonderful colleagues, of which I am a part of. Thank you so much. You are in the daily trenches, trying to bring innovative solutions to legal problems. You are all also very bright and very knowledgeable in your own positions. And I thank you so much for being here and gracing me with your presence. I know it's very difficult as a practicing attorney myself to step out of your firm and take a day or two to participate in a conference. So thank you so much. And I would like to applaud your presence as well. I would like finally, but not least, to thank the students who are present. They are the leaders of tomorrow. They are the Pakistani leaders of tomorrow, the ones that in 10 years from now will be taking the baton from us and will be moving forward with new concepts and new ideas. They are so necessary. So I am grateful that you are here today to participate in this and that you're taking time to build your careers and to think of your careers in a way that you will structure it and be a very active part of alternative dispute resolution in the years to come. So congratulations for being here as well. Thank you so very much. Okay, so let me give you some parameters. Today we will be talking about negotiation mastery. This is a very important part. Many of you may be thinking, why is she going into mediation? Because before you can mediate, you've got to know how to negotiate. So it is one of the most elaborate techniques that a professional in law can develop. It is a technique that you can utilize whether you are negotiating here in your daily life because you are a negotiator involved in ADR, or if you're not. Negotiation refines you. It gives you skills that put you above the rest. It gives you an edge. It gives you an ability. It gives you a serenity. It teaches you how to keep your emotions under control. Now, I am not Pakistani, but I'm Hispanic. So as a Hispanic woman, we come from backgrounds where our emotions, if are not kept under control, can get a little bit out of control. Pakistanis are very warm, passionate people. We share that commonality. So it is very important for our types of cultures to be very understanding and very committed to controlling our emotions when we're trying to negotiate. We are all human. When we go into a negotiation table, whether we are the party or whether we are the attorney, there will be a moment that the opposing counsel or the opposing party will say something that rubs us the wrong way. We must be prepared as professionals to just let it go and keep focused. Because when you are able to do that, you stay on track of your objective and your goal. In the next 2 days, I will be teaching you techniques so that you are able to take those techniques back into the courtroom, back into your practice, back into your studies, and be able to apply them. One of the most important things that you will learn today is that whatever is taught in the next 48 hours will not be enough. ADR or conflict resolution is a life commitment to changing the way you have been practicing your legal profession. It is a shift in the paradigm. It doesn't happen overnight. It's called a practice. Why is it called a practice? Because it requires continuous exposure in order for you to master this ability. As was said in the introduction, I was a negotiator for the United States at the United Nations. I did not get there overnight. Before I got there, there was a long road that I had to travel. And the first road I had to travel was the distinction of knowing that a litigator and a negotiator are not the same thing. I was an inherent litigator. I love to go to court. I love to fight in court. This was my unbelievable passion. And still, for some cases, there's a preference for that. But I have learned that a lot of my cases can be disposed of effectively, efficiently, and timely by using ADR. And for those who are practicing attorneys, I feel you. There's a lot of hesitation right now. There's a lot of concern. What if I change my practice? What will happen to my bottom line? I hear you. I had the same concern. 14 years ago, I had the same concern. And I am here to tell you honestly, as an example, that it doesn't do anything but increment your bottom line. It makes you more efficient. It makes you more lean. It makes you more professional. And most of all, your clients will recognize what you're doing, and you will have more business than you can possibly imagine. Okay, so let's get started. I will need somebody to, okay. So, fantastic. So you've heard, I move around. Yes. Okay, fantastic. That means I'm not tied to the podium. If you will go ahead and do this one for me. For those of you who have taken my class, I don't like to be tied to a podium. I like to move around because that way I can look at all of you, and then I can see you, and then I can learn about you, and then I can pick you to answer my questions. So my classes are very interactive. We're going to be moving very fast. We have a lot of information to cover. And therefore, I use a methodology called critical thinking. Thank you. So critical thinking is a methodology by which the class is not about me, it's about you. You make the class. You tell me the direction that I should go, and I go in that direction because you're guiding me how to teach you, okay? And then you participate. And the way you participate is that we put forth a concern, we put forth a question, and everybody is able to participate. We do it in a very orderly manner, in a very respectful manner. In any case, if you're not respectful and orderly, I have a bunch of judges here that will issue contempt orders for me. So that is not a problem today. So the purpose of today will be for you to take this class and make it into whatever you want to make it, and take from it whatever you want to take. Okay, let's start with Module 1. Module 1 is Understanding Negotiation as Dispute Resolution Mechanism. Explore distributive bargaining, master key concepts like BATNA, SAPA, and Pareto Frontier. Let's talk about negotiations. Before we dive into negotiations, let's talk about our ability to communicate with one another. Communication is one of the most important life skills a human being is born with, okay? How many of you know that even though communication is one of the most important skills that we are born with, we are very bad at it? Not only are we very bad at it, let me add something else. Attorneys, legal professionals are really, really bad at it. We speak like in telegram. We say yes, no, okay, that's it, bye. And I'm sorry, if you're a judge, you're even shorter in those words. It goes like this, yeah, okay? So, as such, we start this training as negotiation as a dispute resolution mechanism. We're going to learn to talk to one another. We're going to learn to communicate. And then tonight, all your wives are going to send me emails and texts saying thank you very much. Okay? So, negotiation. Although negotiation is a human characteristic we are all born with, it does not become a skill until we learn to harness its power. When we master the process of negotiations, it becomes a powerful weapon to resolve conflicts and disputes. In order to master negotiation, you have to understand that every time you talk as a legal professional, every word that you say is super important and carries an enormous amount of weight. As attorneys, please, one of the things that we want to leave on the door today is assumptions. Attorneys do not assume. We do not assume. We deal with facts. We never assume anything. One of the biggest mistakes that I see sometimes is when two opposing counsels are negotiating and they say to one another, oh, but I assume that you were talking about such and such. Or I was negotiating assuming this. This is really a bad way to enter negotiations, because guess what can happen? You can get all the way to a settlement agreement. One of you two can write a settlement agreement, and the other one is going to say, what are you writing? I didn't agree to that. So one of the most important things we have to learn is communication with clarity, okay? Module 1, understanding negotiation as a dispute resolution mechanism. Negotiation is a fundamental skill that is essential in both personal and professional life. It involves the art of reaching an agreement through communication, compromise, and mutual understanding. This lesson will explore the concept of negotiation, its importance, its application as a dispute resolution mechanism. Negotiation is a complex, delicate, and balanced process of reaching an effective agreement using communication and compromise. Negotiation involves two or more parties discussing, number one, their perception of the disputed issue. So you both sit down and you first clarify, what is it that I am actually negotiating? Number two, respective interests. What do I want? What do you want? Number three, working together to find a solution that satisfies everyone involved. Negotiation is very different in that sense to litigation. In litigation, there's always a winner and there's always a loser. In negotiation, we seek a win-win resolution, which means that we compromise in such a way that both parties leave the table satisfied. My best negotiations is when my counterpart says to me, Dr. Chitlik, it was a pleasure negotiating with you. I think we've reached a very good agreement. That means that that person on the other side doesn't feel offended, insulted, but most of all, they too feel that they left the table having done something for their clients. Remember, we're all attorneys here. There is no attorney that can raise their hand and say, oh, I'm okay with losing. I don't know one. Every single attorney wants to get to a table and negotiate in a manner that their clients know that they were the correct person when they were hired. ADR gives you that possibility. Why? Because you retain the control over the negotiation. In litigation, you have to be persuasive enough in order to present to your honor, and your honor here might say to me, that was really nice, Dr. Chitlik, but I don't see it the way you do. and I lost. Okay? Cross-border negotiations or negotiations that involve multicultural parties require a higher level of understanding and much sensibility training to effectively reach across the table and arrive at an effective settlement. We will see this more, but one of the areas that I was privileged to specialize was in cross-border transactions. In cross-border transactions, basically you are dealing with people from different nationalities, different cultures, different backgrounds. You learn very quickly that part of the skill that you have to be able to adapt is the ability to do previous due diligence on who the person will be on the other side, making sure that you are very aware of their customs and their traditions, so that out of the gate, you do not do something that is offensive and turn off the negotiation. I spend many, many hours with my staff before any type of negotiation that involve multiple parties, especially at the UN. You have parties from all over the world, where I would be so cautious because one word could blow the entire negotiation, because in that culture, that word was inappropriate or that gesture was inappropriate. So we have to learn the sensitivity of being able to do that. And when we learn that sensitivity, we can transfer that sensitivity to any part. One of the next things you have to learn is the decorum of negotiation. I have a huge pet peeve. One of my biggest pet peeves is that I have been fortunate enough to litigate in many countries in the world, and I have been given that authority by judges to do that. So I have the greatest respect in decorum when I enter any courtroom, and I find that has been lost, and I find that very, very deficient for us. We are a profession of higher standards. And being able to have that decorum with Your Honor from any part of the world is so essential. And it will be so different for you when you try to negotiate or you try to get that judge to do something favorable for you. So one of the things that I would really highly recommend is that you maintain, no matter how difficult, no matter what that judge is saying to you, that decorum and that respect to Your Honor. You might have to bite your tongue. But yes, Your Honor. No, Your Honor. Thank you, Your Honor. Okay? Elements of negotiation. Communication. We'll talk a lot about communication today. Intuitive communication is essential for successful negotiation. Parties must be able to express their needs, concerns, expectations clearly and respectfully. It is up to each one of you to create an atmosphere where the parties can open up and talk. You are in control. You are the ones that make the difference and give people the opportunity to speak. Why is this important? Because if they don't speak, they're not going to negotiate and you're not going to reach a settlement. Okay? Compromise. Good negotiators know how to make concessions and compromises. This means that both parties often need to give up something to reach an agreement. Okay? I will be talking to you between today and tomorrow about a technique I often utilize when I want to at least give the appearance of compromising. Okay? Nobody's asking you here to enter into an agreement that isn't beneficial for your party. What we're doing is we're asking you to understand that both parties have to give. And there are techniques that visually look very good and do not necessarily translate into having to give up something. I will show you the technique of 3. okay? And in that technique, you will be able to give up something very quickly and be able to lower the guard of the opposing party, okay? Mutual benefit. The goal of negotiation is to find a solution that benefits both parties. They may involve creating value or finding a win-win outcome. The role of negotiation in legal practice. Negotiation plays a crucial role in the legal practice. It is used as a dispute resolution mechanism in 3 areas: mediation, arbitration, and of course, litigation. Negotiation plays a crucial role in the legal practice. It is used in contract formation. Negotiation is essential for forming contracts. When the parties enter into a contractual relationship, they must first negotiate the terms and conditions of the agreement. This may involve discussing price, payment terms, delivery dates, warranties, and how to resolve disputes should these arise during the life of the contract. Reaching a consensus is essential. For those of you who are practicing lawyers and who engage in contract formation, I would highly recommend that you create your own wording. In moving forward, you include in every single contract a dispute resolution mechanism that must take place prior to litigation. I'm telling you that a lot of the headaches that you are now suffering will go away. It would surprise you to know that anywhere between 80 to 90% of the cases in courts now can be resolved with dispute resolution and have no business being in litigation. Yet they are crowding and clogging the judicial system. Okay? Negotiation plays a crucial role in legal practice. It is used to settle claims pre-litigation. Okay, so we were talking about utilizing negotiation as a pre-step to litigation. We will see it also as a post-step to litigation. This is the first part. Negotiation is often used to settle or limit claims. For example, in the United States, if a person is injured in an accident, they may negotiate with the insurance company to settle their claim. Okay? That is pre-judicial. So we go ahead, the famous fender bender, you've all heard that, okay? So you're driving your car and somebody hits you in the back, okay? In the United States, if you're hit in the back by anybody, it doesn't really matter what happened. It's called strict liability. That means that the person that hit you is always guilty, okay? The insurance company, hopefully he has insurance, okay? The insurance company enters into the picture. You call the insurance company. You have your attorney call the insurance company. And there is a process, administrative process, that goes ahead and gives you the ability to negotiate the entire claim before you ever file anything. Courts in the United States require it. Before you file, you must demonstrate that you made what is called a good faith effort. We will be talking about that a lot, a good faith effort. That's when attorneys or their parties make an attempt to resolve the issue. Remember, this is negotiation. You're not obligated to resolve the issue, but you are obligated to act in good faith and morally correctly try to do it without going to litigation. If that fails in the United States, you must show a judge in your filing that the attempt was made and that the attempt was in good faith. And then you can file your lawsuit, okay? Then you get a second bite at the apple, okay, in a court, because at that moment you have what is called or known as a preliminary hearing. At that preliminary hearing, the judge says, go to court-mandated mediation and try to settle it. In there, the parties are no longer, the attorneys are no longer doing it between the two of them, but you bring in a mediator or what we call a neutral to try and resolve or clarify the issues. Okay? We will also be talking about clarification of issues. There are some lawsuits where attorneys are just brilliant, you know, they throw everything at it to see what'll hit. So clarifying what is the issue, what do we really want to talk about, what are we really suing each other for, is an important part of also a dispute resolution. Okay. Negotiation plays a crucial role in legal practice. It's used to dispose of claims during litigation or post-litigation. I'll talk to you about post-litigation in a second. Negotiation is often used to dispose of claims either during the litigation phase of the process or after judgment has been rendered to limit monetary damages, okay? So I'm here and Your Honor went ahead and ruled in my favor and gave me millions and millions of rupees. But it turns out that counsel here is horrified. And he says to me, Dr. Chitlik, can we negotiate? Because my client can't pay those millions and millions of rupees. We go ahead and we negotiate before there's an enforcement of that judgment that Your Honor kindly gave me. Thank you, by the way, for that. And we negotiate, and many times it's much lower than the award. It's perfectly acceptable. We come to an agreement, the parties sign that agreement, I take it back to Your Honor, I said, thank you so much, you know, I was gonna have all that money. My piece was really big, but, you know, my colleague here convinced me we have to come to an agreement. Your Honor kindly puts a seal of okay, you're done. Dr. Zero, get out of my phone. I don't want to see you. Okay? So that's kind of how that works. The balancing act. Negotiation is a fundamental human interaction involving the art of reaching an ironclad agreement. Let's talk a little bit about ironclad agreements. While mediation is not obligatory, okay? You go to mediation and you are not obligated to reach an agreement. Once you reach an agreement, that agreement is signed by the parties. It forms a contractual relationship. Therefore, that document is enforceable. It is obligatory. The important thing about that is that when you reach that agreement, this is why the win-win process is so important, that you don't have a situation where the party that signed with you says, you know, I reached this agreement, but I really reached it in duress. This was not what I wanted to do, or I was bullied into this. And then you have a second problem, which is enforceability. So you want to reach agreements that are logical, that are concise, but they're practical also. I know that we all want to make trillions and trillions of rupees, but sometimes it's just not practical because the client doesn't have that type of money. So sometimes it's better to reach an agreement that is realistic so that we can enforce it, okay? We said at the heart of effective negotiation lies a delicate balance between creating and claiming value, while using psychology to navigate unique differences among the parties. The concept known as the negotiator's dilemma. Welcome to my world. All of you, if you negotiate, are going to leave here with a trauma called negotiator's dilemma. If presents a challenge for negotiators as they try to balance all the aspects of the negotiation and at the same time achieve optimal outcomes. This becomes extremely different. Why? Because we are trying to be fair, just, and balanced, but we're also trying to protect zealously the interests of our clients. Okay? The negotiator's dilemma can be illustrated with an example. Imagine two individuals bargaining over a piece of cake. One person desires the entire cake. Of course you do. We always have an attorney that wants the whole thing, while the other wants half. If both parties insist on their demands, the cake will remain undivided and neither will benefit. However, if they are willing to compromise and divide the cake equally, both parties will receive a portion, creating value for each other. Key to successful negotiation lies in finding ways to create value for all parties involved rather than simply claiming a larger share of the total value. This involves identifying opportunities for collaboration, exploring mutually beneficial solutions, and leveraging shared interests. By focusing on creating value, negotiators can expand the pie, ensuring that everyone walks away from the table feeling satisfied. What does that translate to? Very, very simple. It is important as negotiators to think out of the box, okay? As litigators, we are put in a box. We are not asked to think out of the box. We're asked to follow procedure and to execute in accordance to that procedure. As negotiators, you remember when you were a little kid and you went to school, I don't know, here in Pakistan, but in the United States, it was like that. And you were really, really little, and then they would give you a box of Crayolas, and you would have something that you had to paint a house or whatever. And they would say to you at the beginning, they would say, you can paint anywhere. And you would paint it all over the place, out of the box, out of the house. This is negotiations. Negotiations can be as elaborate as you want them to be. They can be the type that even you bring a situation to avoid impasse. We will be talking about impasse very shortly. Impasse where people get stuck. You can go ahead and give new ideas to keep the negotiation moving. Because when you're talking, you will hear that there are other interests that may be utilized to negotiate. So you have to pay good attention to what a person is saying, so that if the things that you are particularly negotiating are not moving, you can bring another element in and move the negotiation along. Okay? This involves identifying opportunities for collaboration, exploring mutually beneficial solutions, and leveraging shared interests. Okay? Module 1, explore distributive bargaining, known as claiming value, and integrative bargaining, known as creating value. We'll see the difference. Bargaining as a whole is a fundamental aspect of human interaction. It is the process of negotiation to reach an agreement. It can take various forms, but two primary strategies stand out: distributed bargaining and integrative bargaining. These approaches, while similar, diverge significantly in their objectives and tactics. Okay? One thing that I'm going to tell you is do not confuse bargaining with haggling. Okay? I have had people in this class that say, well, I'm an expert bargainer. I go to the market and I go ahead and I make sure that I get the price I want on my tomatoes. That is not the same thing. That's haggling. That's a totally different approach, and it is not something that we utilize in negotiation. Okay? Bringing somebody down in the price is not necessarily the most effective way for negotiation. It doesn't create necessarily a win-win scenario. Remember, your platform is creating a win-win scenario. Okay? Bargaining is a simple form of distributive negotiation process that is both cooperative and positional. Okay? Meaning, bargaining doesn't seek to create value, but instead focuses on the negotiators claiming value. Bargaining very often revolves around a simple issue. For example, the price or things with monetary value. Okay? So if you do not see money in the transaction, it could possibly be something of value. What would be an example of that? Okay, you have a divorce proceeding. Okay, and there are children involved in that divorce, and there is a custody issue. Children don't have a monetary value, but they're priceless. Okay, that is your value right there. That's where you have to concentrate so that you create a win-win scenario for both sides. Okay? Wise negotiators realize the importance of both working together and asserting their interests at the bargaining table. They seek to expand the overall benefits for all parties by identifying areas where they can exchange concessions and reach mutually beneficial agreements. Savvy negotiators see the bargaining table as a buffet of food. They aim to enlarge the number of options for everyone involved, ensuring that all parties leave satisfied by carefully selecting and trading dishes. What does that mean? How does that translate in a negotiation? It can translate like something like this. I'm sure, esteemed counsel, I don't have to tell you, but you know that in addition to this opportunity, there's this opportunity and this opportunity. You know counsel doesn't have any clue about these opportunities, but you are expanding by letting him know. And what is the counsel going to say? Oh, yes, of course. And all of a sudden, you have expanded the possibility for a negotiation. Okay? Claiming value. Distributed bargaining is a competitive approach known as claiming value, which focuses on maximizing individual gains while minimizing the other party's benefits. In this scenario, one party's success directly leads to the other person's loss. Okay? Typically, distributed bargaining involves dividing a fixed resource like money or time between opposing parties. This is the example of the child custody situation. You divide the time and you create benefits for both sides in a divorce proceeding. Okay? The primary goal of each side is to obtain the largest possible portion of these resources from the spouse. So they go ahead, they divide the time, and then one parent says, I want more time. Usually it's the custodial parent. The custodial parent will say, I want more time. The non-custodial parent is always fighting for more time. Okay? So that is a typical example where you see this. Common strategies in distributed bargaining include making concessions. Okay? I cannot tell you how important it is that when things get very difficult, if you have somebody that is willing to make concessions, this is extremely positive in any negotiation. The next thing you do not want to do, and I'm sorry, I am telling you right now, attorneys control your clients. Your clients should be briefed before they enter the negotiation table so that they do not say anything. That's why they hired you. You're the experts. You should be the ones leading everything and communicating with opposing counsel. You do not want a client that is irate or out of control, that's going to say something that's going to completely turn off the negotiation. We've all had scenarios where clients lose their cool and they say something that is offensive, and all of a sudden the other person turns and says, I don't want to continue this negotiation. Remember that in negotiations, like in mediations, once one party says, I don't want to continue, you are ethically obligated to stop. This is why you don't want to go there, okay? Issuing threats, okay? Counsel, you know, we are zealous. We are zealous. We are special in many ways. But one of the things that sometimes we have to control is issuing threats as counsel. Nobody likes that. That is a huge no-no and a big turnoff. I understand that you can say something like this. I understand please understand if we don't reach an agreement today. Unfortunately, my client and I will have to resort to looking at our legal options to enforce this, whatever, okay? But it's very different to turning around and say, if you don't reach this agreement, know that we're going to sue you for everything you've got, and we're going to tie you there for years to come. And it happens, and you hear it. Usually when I hear a counsel say that, it is a counsel that is immature and doesn't know how to negotiate. Mature counsel will never resort to that type of word or anything of that nature. They want to continue the negotiation going. That stops the negotiation. Once parties are not talking, there is no possibility for any agreement. Okay, ultimatums, okay? Be very careful. They can be issued, but you got to be careful. You got to be classy. You got to be very cautious how you do them. Explaining to the other side what will be the natural progression of the process is not an ultimatum. You're providing facts. And it is very important because sometimes when you do that, please do not assume that counsel on the other side has explained all the outcomes of not reaching a negotiation to their clients. Most cases, you will find that the client on the other side will look at his attorney and say, you didn't tell me that. Okay? You need to keep that in mind and take advantage of that, but do it in a classy way. Number 4, employing aggressive negotiation tactics. Very similar to what we were talking about. We just don't want to go there, okay? Creating value. Instead of focusing on maximizing individual gains, parties and integrative bargaining aim to identify, number 1, common interests, trade-offs, and synergies, okay? One of the easiest things one of the first things that I do is I have a piece of paper, and when we clarify what are the things that we're aiming for, I write them down for both sides. I intersect them where counsels and mine are the same. I circle it on my paper because this is for me to remember that this is the part where we can meet mutual ground and we can move from there. I don't emphasize or concentrate on the things where we don't agree. That's a bad place to start. I concentrate first on the areas that we agree, and then I work outward. Because if counsel on the other side feels that we are working and progressing, they will be most likely to do concessions. And if not them, their clients. Clients like to see things moving positively. And when clients start to feel that momentum, and you will know that momentum, they will themselves talk to counsel and say, it's okay, that's not that important. We can reach an agreement with that. and you move forward. Okay? This approach of creating value often involves problem solving. Okay? You want to make sure that the issue that's being brought up is exactly the issue that you're really trying to negotiate. These are very tricky. Sometimes in contract breaches, sometime in domestic relations cases, the issues that one party is bringing up is not really the issue. So you must uncover what is called the pain. You must uncover the pain. What does that mean? You must uncover what's behind the issue to reach what is really bothering the opposing side. If you are able to discover what is really bothering the opposing side, you have a better chance of settling the dispute. Okay? Sometimes contract formation and contract breaching can be something as simple as one side feeling that they were disrespected in the breach of that contract. If that is the case, you must move quickly as counsel to acknowledge that and make that issue go away. Because if somebody on the other side feels disrespected, that there's been an injustice, that they've been taken advantage of, you are not going to be able to move forward. You've got to take that out of the way. Okay? Brainstorming. Don't be afraid to brainstorm. Okay? Brainstorm among attorneys. Do not bring your clients in. You always brainstorm, you with opposing counsel, and then when you have brainstormed, you say, I will convey this to my client. Okay? This is very important. Okay? One of the ethical things that we will be talking about tomorrow is the ethics of conveying information to your clients. I understand we all think we as attorneys know better even than our clients. But even so, it is your legal obligation, ethical and morally, that when there is a negotiation, you must bring in your client and tell them all the ramifications of that negotiation. Even if the price is not, if you're negotiating price, and even if the price is not what you want it to be, you need to convey information to your client. What you don't want to be caught on is your client finding out that you did 3, 4, 5 steps without them knowing. They don't like that. They don't appreciate that. Clients will respect you, and they will allow you to have autonomy in your dealings when you are transparent with them. Okay? Compromise. Again, we're talking about compromise, giving a little from both sides. Module 1, defining master key negotiation concepts like BATNA, SAPA, and Pareto Frontier. BATNA, what's BATNA? BATNA is defined as the ability to identify a negotiator's best alternative to a negotiated agreement. When is BATNA most commonly used by negotiators? When your current negotiators have reached an impasse. The negotiator looks to see what is the best outside option or the best no-deal option. Okay? What is an impasse? An impasse in negotiation refers to the point where parties involved are unable to reach a mutually agreeable solution or compromise, leading to a standstill in the negotiation process. This often occurs when there are significant differences in perspectives, goals, or interests between the parties, making it difficult to find common ground. Okay? In demands for money, okay? In the United States, when we do demands for money in cases involving liability, okay? If you have a situation where you do not know how to price your case, you will have an attorney that will want $3 billion. And then the other attorney who is willing to pay $100,000. Okay? Obviously, you're not even on the same planet at that point. Okay? So that's not going to work. There are cases when you're dealing, that's another thing, that you should deal in realistic expectations. We talked about that. The case is worth $100,000 and you have a attorney that asks for $100,000 and the other attorney says, we are at 80. Okay? There you got a point. At least you're in the same planet, the same address. You can negotiate from there, okay? 2 common schools of thought regarding the use of BATNA. BATNA as an outside option is the first school of thought. But then there's also BATNA as a no-deal option. Let's look at it. BATNA is often defined as an outside option independent of one's current negotiation or proposed agreement. Okay? It is the out-of-the-box option. Steps to access BATNA. Number 1, list your alternatives. Okay? If we don't settle this contract, what is my alternative? What happens? Who can tell me? If there is a breach in a commercial contract, what happens if I and my client do not settle? Give me one repercussion of not settling. Anybody? I'll start picking. Yes, sir. Damages. There'll be damages. Talk to me more about those damages. What will happen there? Fantastic. Thank you, sir, for being the first brave one. Who else is brave? Come on. Who else is brave? What else will happen? What is the other repercussion? Yes, ma'am. Thank you so much. Now, a point for the other gender. Come on, let's go. Tell me.
The threshold of that damage is very high. In that case, that's incentivized settlements. Parties should go for the settlement. And if they don't go for the settlement, they decline the offer, they don't do anything, they get to higher, they have to pay the higher cost, or the threshold of the compensation will be very high.
Fantastic.
So it will push the parties to go back to the settlement.
So what happens is, what you're telling me is that the breach of contract can eventually lead to escalating of costs, huge escalating of costs. Fantastic point. Now, immediately, okay, I have so many brilliant high-level academics here. What happens immediately when a contract is breached? Just a simple thing. Yes. Yes, the breaking down of the business relationship. Yes, the breaking down of the business relationship. Also, the reason why we contracted. You were going to sell me these widgets. I didn't get my widgets. So the business that we were transacting also got stopped. So this is the immediate list of things that happen. Okay? So if this contract doesn't go further, so business as we know it for this company that is involved in this contract stops. Okay? What are the alternatives that a company has in a breach of contract? Alternatives. Come on, my counselors, my experts in contracts. What alternatives do you have when there's a breach of contract? Yes, sir, Your Honor.
In this situation, there are 2 modes.
Okay.
Basically, practiced in Pakistan. The first one is the alternative modes,
Okay.
like negotiation,
Okay.
and the mediation, etc.
Okay.
And the second option that is rise to the party, the litigation.
Okay.
So we can resort if the clause is mentioned in arbitration clause that it will be settled by arbitration. If it is clearly mentioned that there is no need for any arbitration, then it will be moved towards courts.
Thank you, Your Honor. Thank you so much. Anybody else? Yes, sir.
Apart from all these what have been mentioned by the honorable sir, there are certain things which leads to towards the compensation because the contract is broken. Now, what the aggrieved party can obtain, that is the way that is it has been mentioned as the damages. Damages are filed for the compensations. If the contract already speaks about the compensation, there is no need to file for the damages. So also to go for the ADR process as well.
Fantastic. Thank you, Your Honor. Thank you so much. Anybody else? Anybody else? Yes, sir. A specific performance. Talk to me about specific performance. Great. Okay. So you establish your BATNA. You calculate your reservation value and the lowest value deal you are willing to accept. Okay? So this is where I want to be, but in case things don't work out, here is where I am able to still reach an agreement and feel comfortable. Okay? BATNA as a no-deal option is defined as a negotiation determination of the action to be taken if no deal can be reached. Okay, this was the example I gave you guys. Should we not reach an agreement, my client will move to enforce their rights in court, aka client will sue. Okay? SOPA is defined as a zone of possible agreement. Okay? It's where the two parties can find mutual interests. This is the area of overlap among each party's BATNA. It is the space where both parties can find common ground to strike a deal. It is also known as the 80-20 rule in Pareto effect, which states that 80% of the results comes from 20% of the causes. In simpler terms, a small number of factors can have a large impact on the ultimate outcome of a negotiation. Pareto efficiency is crucial in negotiation, especially when parties aim for agreements that benefits themselves without harming others. Okay? Striving for Pareto improvements can yield resolutions that are beneficial for all, promoting cooperation in negotiations. How to apply Pareto principles. Number one, each party identifies core interests. This is very, very important. So you go into the negotiation table and you want to identify clearly what both parties are going to negotiate. I know it sounds like ridiculous what I'm telling you, but you would be surprised how many times you are not negotiating the same thing. Write it down. Write it down. One of you will be writing it down and have the other person look at it, other counsel look at it, and acknowledge that they are in agreement that this is what you are negotiating. Why? Because you have the other type of counsel who goes ahead and all of a sudden in the middle of the negotiation wants to expand the claim to things that we are not talking about. Okay? That just confuses everybody. So you want to keep everybody aligned by writing these things down, having both parties acknowledge it, because it creates accountability. Okay? Rank goals by importance. Once you've done that, say, okay, what does it take to go ahead and strike a deal? Give me these in the order. Rank them 1, 2, and 3. 1, 2, 3, 4. Focus on the most vital. 1 and 2. 3 and 4 should be discardable, or at least the negotiation part. 1 and 2 should be your most important ones. Remain flexible and creative. Okay? I can't give you the house, but I'll give you the boat. Okay? I can't give you the dog, but I'll give you the cat. Creative. Very, very creative. Communicate priorities. This is very important. Communicate those priorities. Check consistently throughout the negotiation that those priorities remain the same, because they may shift through the negotiation. Okay? After the break, we're going to go ahead and do this. Go into module 2. Before the break, we are going to go into a time of exercise. So we are going to go ahead and do a little bit of the exercises. We're going to go through Fatima, and we're going to go through SOPA, and you guys will have the opportunity to identify these scenarios so you can become comfortable. Please, just, everybody's learning here. Don't worry about it. Just say what comes to your mind. This will open the floor for discussion, and we will be able to go ahead and really, really hone in on this. So let me get my examples. Okay. Okay. Let's start with an example of SOPA. Okay? Example number 1. Tim wants to buy a used car for 5,000 rupees or less. I know, there's no such thing, but, humor. And Jane wants to sell a used car for 4,500 rupees. Those two have SOPA? Yes or no? Yes, Your Honor. Huh?
Yes.
They do. Tell me, Your Honor, why? Beautiful. Anybody else? Beautiful. So Your Honor says there is SOPA. Anybody else? Yes. Yes. So you believe there is SOPA? Yes, because of the proximity they are in the price. Thank you so much. Thank you. Wonderful. Okay. Now, let's say that Tim wants to buy the same car, but he will not go above 5,000 rupees. And Jane, in turn, will not sell her used car for less than 7,500. Do these two have SOPA? No. Can anybody tell me why? Okay. So what happens when there's a huge difference between the price? Okay, and what is SOPA? What was SOPA? Can anybody define for me what SOPA was? It's the possible, reach the possible agreement, because it's the zone where they what?
They can negotiate.
They overlap. Who said that? You did? Fantastic. It is the zone where they overlap. Fantastic. So in this case, you can't overlap if both sides are willing to go lower. Okay. Fantastic. People are paying attention. Now, okay, let's go to a combined Batma and SOPA example. Tim has a Batma of 7,500. This means he will not pay more than this amount for a used vehicle. That is his ceiling. While Jane considers that 6,000 is the minimum amount she can sell her car for. Do these two have SOPA? Yes. They do. Why? Yes. Okay. Okay. Very, very good. Okay, now let's start calling people up. I need two very brave people to come up. I need two very brave people to come up. You can sit here in the reserved lounge area. Two very brave people. Come on. Oh, you gentlemen here, and there's no brave. Oh, there you go, Your Honor. He's taking one for the team. Come on. You two? Fantastic. He's taking one for the team. Your Honor, please come on up. You two, please sit next to Your Honor. I promise you he won't bite you. Okay. Each pair represents two attorneys, sorry about that, negotiating for their client over a cow. A cow. You are negotiating, Your Honor, over a cow. One cow. Not a mountain, just a cow. One client wants, okay, you want the entire cow. Your client wants the entire cow. While you, Your Honor, because you are a man of the bench, are more wise, you want to kill the cow, okay? And keep some of the meat of the cow and then give some of the meat of the cow to the other. Okay? Okay? How would you two negotiate the cow? So I will give you 5 minutes to talk about you two. And all of you will also, amongst you, sitting, negotiate to see if you come to the same conclusion, whether it's an impasse. You're allowed to do, these are the rules. You're allowed to reach an impasse. No negotiation. You're allowed to be out of the box. Very creative. Okay? So those are the only rules. Everything else goes. Okay? And you are allowed to supplement the situation. Not more cows, but you're allowed. yeah, no. Because Your Honor's like, can I just bring another cow and give it to him? No, you cannot do this. Exactly. Yeah, I know. Yeah, no, it doesn't work that way. Not in real life. So 5 minutes. 5 minutes. You have 5 minutes. So basically, 42. At 42, you guys must have some sort of decision for us and share it with us. Okay? Hopefully. Okay. Everybody, you guys within your groups also decide what happens to the cow. Does the cow live? Does the cow die? What do we give?
Yes. I have a question.
Yes.
The person who needs meat, who wants to distribute the meat, is it for personal purpose or for commercial purpose?
You can go ahead and do it in either way. Personal, yes. It's like their choice. It's the same way your choice. Okay, what we're focusing here is the resolution of what's the fate of the cow. You know, this is like a soap opera. It's the poor cow. Yeah, survival of the cow. You are the negotiator. You can be whatever, you can do whatever you want. Yes. Yes. See.
I promise.
Excuse me, mic on.
It's really funny. It's really, really funny. Oh. That's okay. That's okay. You guys are so engaged. I'm loving it. You guys all in the back already figured it out. You're like, we're done. We're done. Yeah, we're done. Yes, I want to tell you that this was most likely one of your most important judges in the format of a negotiation, this cow. You will remember this cow forever. This will go in your memoir. Yes, yes. So I want to ask a question. I'm going to go to the psychological. So you were negotiating with a judge, okay? You know, he's a judge. Did you feel any pressure because he's a judge?
No, not.
Okay, good, good. Did you are in your position as a judge, did you utilize your position as a judge to enforce or to get to an agreement? Good. 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 Wonderful. Wonderful. Thank you. Thank you. That is so important because this is a common scenario that can happen. Okay? And you just heard it from Your Honor and my colleague. Okay? This is, Your Honor, you couldn't have said it better. It's irrelevant. Completely irrelevant. Now, please dazzle us with your conclusions.
We have concluded that we, instead of just slaughter the cow and have a barbecue party as suggested by members, we finally arrived at the conclusion that we should just sell the cow and keep the half shares equal.
Oh!
Because before that, we thought the keeping cow with one person and the other person would get the milk out of it. So the monetary complications and requirements were, in the side. So after discussing about those monetary complications and repercussions, we thought the gentleman say, okay, let's keep the calf of the cow with you, provide me with the milk. I thought, how about the money? How would I feed the cow? How would I feed the calf of it?
Wow.
So by taking the creative, measures, we thought, let's sell it.
Unbelievable. What a great, how simple, yet how thought out. Fantastic. Thank you so much. Big applause. Big applause. Big applause. Because you guys are so great. Thank you. Anybody else have a different outcome they'd like to share? A different outcome. Yes, yes. I'll give it here to the colleague and then I'll give it to you.
एसेंस से कहें कि कोऑर्डिनेट करें माइक पकड़ाने में एक तो वो हीरो बन के सैर कर
Oh, so he will keep the cow and compensate you out of his own pocket. That's fantastic. Totally different. Anybody else have a different one? Thank you so much. Yes, Your Honor. Tell me. Talk to me. Uh-huh. Okay. Uh-huh.
he will sell the milk
Uh-huh.
and he will give half of the milk to A. A is just farmer use of making expense of grass
Yeah.
and B is the product that will sell this.
Fantastic. That is a great solution. Thank you so much, Your Honor. Anybody else? Yes, you had one.
ये माइक चल नहीं रहा
Okay.
voice is
So a totally different animal will be introduced into this equation. Okay. To create fairness. Is the animal, what animal is it? Another cow? Okay. Okay, fantastic. I love to hear these out of the box. Anybody else have another one that they want to share? Yes. Yes, yes, yes.
My situation with ICT that maybe one party is a
नहीं चल रहा बच्चे
some parts of that car.
Microphone down.
Okay.
So they can negotiate for the better interest which models they want to use, like phones or something else. So they can distribute the part after starting it, and one gets the bill and other gets the margins for the.
Unbelievable. That is a really thought out process. Fantastic. I love it. Thank you so yes, sir. Now you guys are getting warmed up. Yes, I love it. Okay. Tell me.
In fact, we are discussing the law,
Mm-hmm.
but unfortunately, the law is coming.
Stolen. Oh my goodness.
So both of us are looking for indication to get the go back from the thieves. And thereafter, the matter will be solved.
So you reached an impasse. Well, that's very creative. That's extremely creative. I've never had that one before. That is really something. So the cow was stolen while you were negotiating. Anybody else? That's fantastic. Absolutely fantastic. We have time for one more before we break. I need two more very brave participants. Come on. I would love the judiciary to lead the way. Somebody from the judiciary and one of my colleagues or a student. Yes, the lady. You know, they're the future. Yeah. Okay. Since you are from my younger crowd, we're going to make it a little bit more to your age. Okay? So, the case at hand is, okay? You, my dear, went out, and this is the season to prepare for the fall. So you wanted a leather jacket, okay? You went ahead, you bought the leather jacket, and you ordered it on Amazon, okay? They gave the description incorrectly. And when the leather jacket came, okay, it was too big for you, okay? However, my colleague here says, oh, this leather jacket fits me perfectly, okay? So he is interested in buying the leather jacket, except there is one problem. When you went and got the leather jacket, you got it in one of those sales, end of season sale, okay? So she paid only 5,000 rupees. I seem to like 5,000 rupees. 5,000 rupees for this leather jacket, okay? He knows that she paid 5,000 rupees, but she now wants to go and get the leather jacket in her size. but the leather jacket is no longer on sale. Now, for her to get her leather jacket, she has to pay 10,000 rupees. So, she has to sell the leather jacket for at least 10,000 rupees or somewhere there, or reach an agreement with the gentleman who knows that she paid only 5,000. How are you going to reach that agreement? You have 7 minutes to reach it. Okay? Okay.
Is that category so that the shop is
Is it you tell me. You tell me. Whatever I don't give you, you can add. Like for instance, my colleague back there, he had thieves. The poor man was negotiating and had thieves and they stole his cow. I will remember that example until the day I pass away. So this is how creative you can get. Okay? Leather jacket, guys. Leather jacket. They're very fashionable. You all look very good in it. Okay? So you're trying to secure a leather jacket and take it off the hands of the lady. Okay? 7 minutes. 2, which is the Islamic portion, before we go to lunch. Okay? So please, by all means, go ahead and take the opportunity, if you don't want to, at least to walk around and get re-energized. Thank you so much. Really appreciate this morning session. You guys are fantastic. Thank you. an answer. I'll give it to you in a second, Your Honor.
Then we negotiated on the jacket
Yes.
and he agreed to sell it to me at 7,500 and I convinced him that this is cannot be returned to the seller.
Uh-huh.
And he will give you 5,000 and for my benefits I will have 10,000 jacket at 7,000. So he agreed that he sold it.
Fantastic. So you persuaded the gentleman with this jacket that anyway, 7,500 was better than nothing. Fantastic. Wow, that is great. I need to go to Your Honor and then I'll come to you. Yes, Your Honor, you had a question.
Ma'am, my question is that the question regarding also agreement,
Parental.
negotiation arises only when there is a dispute between the parties. In the situation under discussion, when one party has not made an offer and the other has not accepted yet, and there is no agreement between the parties, one have purchased the jacket, but the other wants to purchase the same. They have not agreed between agreement between them to sell and purchase the jacket.
Right.
So my question is that whenever there is no dispute between the parties, no agreement in peace between
Okay.
the parties regarding any sale or purchase of this property,
Okay.
then the need of negotiation doesn't arise. Kindly,
Excellent question. Excellent question. So Your Honor says that in his perception, SOPA and it requires the arising of a contract or the arising of getting to a point of a contract, and if that doesn't happen, or a dispute, okay? Now, that's a very, very good way of looking at it. However, SOPA goes beyond that, and this is the beauty of it, okay? Says, can anybody that I don't have to answer that question for me? Your Honor, do you want to answer that question for me? Why?
The thing is that the situation which you are talking about, that indeed that has not arrived at yet, that the dispute is not there. But the question, the situation suggests that the two parties could come at a conclusion by way of bargaining. What we have learned today in the first session, they are bargaining at a value of a thing which is yet to be consumed by anyone. So in that situation, the ideal situation, what I believe would be that the first party who has already, purchased that boat, he or she can sell it to the other person at the same price, number one. And number two, by way of consumer protection law, she can ask the Amazon to compensate her by providing fresh piece of her size, because the description which they provided was not proper. So to my consideration, the question does not arise for the area here yet.
Yes.
Because indeed the contract is not there.
Right.
But they are settling for, they are negotiating for to come a conclusion with regard to selling of that boat.
Correct. Correct. You are absolutely correct. So this is very interesting. So it's a step before there's even a dispute. It is the negotiation portion of it, even when the dispute arises per se, because you can't agree on a price.
Yes.
So that's the moment that triggers that dispute. But you can begin that now and SOPA prior to that, and then culminate because there is a dispute, and then you go into the part where you see if something overlaps or not, and you can come to an agreement. So there doesn't have to be a dispute, there just has to be a negotiation.
For negotiation, there is no need for a dispute to be there.
No need at all.
Yes.
No need at all. What happens is that most times you rarely have a negotiation where one party says, how about we do all this? And the other party says, oh, absolutely, okay. And then the moment that the party says, oh, no, wait a minute. No, I don't, I'll agree to this, but not that, there's your dispute. What we must not confuse is that the legal word is dispute. It doesn't mean that it's unamicable, or it doesn't mean that we're fighting. It's the legal terminology, okay, for it. So there's nothing bad with using the word dispute. It's just basically two people not agreeing or not seeing something. Okay?
Ma'am, question
Yes.
is there
Yes.
that when there is no agreement between the parties,
Yes.
enforced by the law, then one party may, when in the situation when he has not made any offer,
Yes.
in the situation when he has not made any offer and there is nothing to compel him to enforce the agreement or his offer when he has accepted the same.
Okay.
In that situation, you have told, and my teacher and brother has also that the agreement, the negotiation can be made for bargaining.
Right.
I am saying, my question is that when one has not made an offer and the other is trying to negotiate him for bargaining purpose, he simply says that I am not going to sell my property.
Well, then there is no negotiation.
Then
You are not engaging in negotiation, because in order to engage in negotiation, you must have both parties participate.
that's why I am
Okay.
asking that
Yes,
there must,
yes,
must
you are
be an
correct.
offer and acceptance and
Well,
an agreement.
no, there must
to
be a
enforced.
participation of both sides. A participation, an active, yes, sir. Yes,
Just like those two people are chit-chatting.
yeah.
Well, no,
That's negotiation.
Yes,
Sir,
yes, it is.
We and my level,
We are-
we are sitting here, we
Uh-huh.
are just chit-chatting and can it be
You
defined as negotiation?
can you morph a conversation into a negotiation, is what your honor is asking.
I want to make an
situation,
Huh?
I want to make a
Yes, yes,
because when the scenario was given to us, it clearly states that other colleagues says it fits me perfectly.
yes,
Then they move towards sharing a table and having negotiation. So
right,
the given scenario and the facts here depicts that the both parties are
willingly and voluntarily agree to sit on the table and negotiate for something,
bingo,
whether at the end it is successful or
bingo,
not.
bingo, bingo. The act of you're talking with your colleague, okay? And all of a sudden your colleague says, you know, I really love Karachi and I would love to retire in Karachi. And you think to yourself, wow, I got a piece of land over there in Karachi that I want to get rid of. And you say, you know, what are you looking for? Well, I'm looking for 4 acres and I got 4.5 acres in Karachi. Boom, that has turned, the tide is turning into a negotiation. If he says to you, well, Your Honor, I'm interested, let's talk about it. You have just turned the conversation into a negotiation. You don't have to reach an agreement. I think what's confusing you is you think that there has to be, there may not even be an agreement, but because it turns out that you think your piece in Karachi is super, super special and you want him to pay $40 million. And he looks at you and says, no,
there's no compulsion.
no compulsion.
No compulsion.
I would like to add a
Yes,
I think,
Your Honor.
the proceedings and the negotiations. And we are talking about media. Media are generally the legal proceedings after the dispute arises between the parties.
Exactly.
But as far as the negotiation is concerned, we are prior to the agreement as well.
Exactly.
Whenever you have to reach to the agreement, you
Yes,
have to negotiate between
yes,
both of the parties, have to negotiate between
yes,
themselves. So that negotiations along with the media negotiations,
yes.
both have the ingredients within it that both are important. So I think
We're adding one more layer. I'm actually trying to make your jobs easier as judges. We're trying to teach legal professionals to step one layer more. Engage in negotiation, and then if that fails, have the court mandated mediation as a second option to try as much as possible to get this matter resolved and get it off of your calendars. This is what we're trying, the culture we're trying to teach at this moment. That there is no limit to how you can we're trying to make negotiations so easy that you can turn a simple conversation into a negotiation so that it becomes instinctively for legal professionals.
I'm very sorry, I have to make another question.
No.
Leonard, please has said that I am confusing. I am not. My question is still there.
Okay.
I have made a simple question
Okay.
that whenever a person has not made an offer and the other has not accepted the said offer, no question of negotiation
No question of
does arise at all.
No, there isn't.
Because if the other person asks for negotiation, the first person who owns the property, he says simply that I am not interested to sell.
That's it. They're done.
The matter is closed.
The matter is closed.
So the question, the matter, as per my understanding, is that the question of negotiation or bargaining starts at the moment when one person makes an offer and the other accepts it.
Well, we gotta be careful with that
Until and unless-
because offer and acceptance leads to contract and you're not there. You gotta be careful. I'm trying not to confuse people. Remember, offer and acceptance leads to contract, even if it's verbal. So we don't want to go there. What we want to say is that the negotiation opens when somebody is interested in a particular transaction and the other one engages that person in that particular transaction. Because if you have offer and acceptance, you're done with the negotiation because you've created a contract.
Can I conclude that the end of this negotiation does not lead to any legal consequences? Whatever may be the result of the negotiation, there are no legal consequences.
Unless you have an agreement, yes. Unless you have an agreement, yes, because what you don't want to do, but in Pakistan you can enforce oral agreements as well. So you gotta really be careful with that. So I think you have to set the parameters in negotiation in Pakistan to say this is purely a negotiation until we reach a document agreement in writing. There will not be an effective settlement because then you can have one of the parties say, hey, you know what? I agree, Your Honor and I came to a verbal agreement and I want to enforce that, and then we have a problem.
I think we can add something, but Your Honor is trying to say is that there has to be an offer. There has to be an offer for the willingness to go into negotiation. And if the other person does not accept it, you cannot get into negotiation.
That
So
is correct.
that's what he is basically
Yes,
referring to.
yes.
There has to be an offer and acceptance to get into a negotiation.
There has to
And
be
unless there is no
an offer.
willingness, then you cannot get it.
I would say there has to be an offer and a willingness, without the acceptance. Yes, but of course, please, this enriches the conversation, thank you.
The scenario which initially spoke was that A was willing to sell out her court and B was willing to purchase that court.
Yes.
So here we are.
Yes.
We have got that initial, terms
Yes.
to agree or to disagree.
Yes.
So technically, we are there in the scenario of the negotiation.
Yes.
So I'm still.
I think that Your Honor was outside of that scenario. You were
Yes.
just posing the question in general.
What my brother has said, that is the offer and acceptance indeed.
Yes, and those are the prerequisites
of
of
the property
sir,
and the willingness of the other to purchase the same. That
You
is
must-
an offer and acceptance.
then you must
Third
appreciate.
term, the consideration has to be discussed.
Exactly,
Yes.
because there is no consideration.
Exactly.
There you go. You're missing
So you
consideration.
must agree.
Thank you, Your Honor.
You must agree.
Yeah.
Yes.
Yeah.
So you must agree that there was, sir, I'm referring to you, sir. So you must agree and appreciate this, that there is no anything which requires ADR yet, because they have not arrived on at any kind of agreement yet. They are discussing the facts, they are discussing the legal terms of the agreement. So if they agree, fair enough, then the legal complications would arise later on. If they do not, so there they go.
There you go.
Yeah.
There you go.
This is simple. Thank you very much.
Thank you so much, Your Honor. Really appreciate it. This is what makes this so interesting and wonderful. Everybody did fantastic. Now, let me move on to Islamic principles of negotiation. Okay, so we'll be looking at explore the role of Islamic principles in Pakistani negotiations. We're going to do justice, fairness, and compromise. Number 2, we're going to understand the emphasis of fulfilling agreements and seeking mutually beneficial solutions. And number 3, amicable resolution, the Islamic principle of maintaining relationships. Okay? Module 2. Islam offers a comprehensive framework for human conduct, okay, including principles for negotiation. These principles are rooted in the Quran and the Sunnah and the primary sources of Islamic law. The central tenet is the importance of justice, fairness, and honesty in all dealings. The Quran emphasizes the importance of equitable treatment and fair dealing. Negotiations should aim to achieve just outcome for all the parties involved. I find this beautiful because it cannot be more of what we're talking about right now. Deception and dishonesty are strictly prohibited in Islam. Negotiations should be conducted with transparency and integrity. Muslims are encouraged to treat others with respect and dignity. This includes respecting different opinions and viewpoints that are contrary or opposite during negotiations. Islam teaches patience and perseverance in the face of challenges. Negotiations may require time, patience, serenity, a cool head, and effort to reach a satisfactory outcome. Consulting with others and seeking consensus is a valued practice in Islam. In negotiations, seeking input from trusted advisors can help ensure a well-informed decision. Avoidance of harm. Islam emphasizes the importance of avoiding harm to others. Negotiations should be conducted in a way that minimizes negative consequences for all parties involved, including the loss of relationships. The Islamic moral compass. Described principles provide a moral compass for Muslims engaged in negotiations, ensuring that their actions are aligned with Islamic values. By adhering to these principles, Muslims can strive to achieve just, fair, and harmonious outcomes in their negotiations. Fulfill agreements. In Islam, fulfilling agreements is a fundamental principle that is deeply rooted in the teachings of the Quran and the Sunnah of the Prophet Muhammad, peace be upon him. It is considered a moral obligation and a reflection of one's faith and character. Fulfilling agreements. Key reasons. Number 1, trust and reliability. When individuals fulfill their agreements, they establish trust and reliability in their relationships. This fosters harmonious interactions within communities and promotes a sense of security and stability. 3, justice and fairness. When agreements are honored, justice and fairness are upheld. It ensures that everyone's rights are protected and prevents disputes and misunderstandings. 4, economic prosperity. Fulfilling agreements is essential for economic prosperity. It promotes trade, investment, and cooperation, leading to a stronger and more vibrant economy. 5, is spiritual rewards. Islam emphasizes the importance of fulfilling agreements as a means of seeking spiritual rewards. Those who honor their commitments are considered to be following the teachings of Allah. The Quran provides numerous verses that highlights significance of honoring agreements. 2.177, those who fulfill their covenant when they make one, and if they break it, they will be punished with a painful torment. 5.1, O you who have believed, fulfill your covenants. 16.91, fulfill your covenants when you make them. Mutually beneficial solutions. Islam places great emphasis in the importance of fair and mutually beneficial agreements in all aspects of life. The principle rooted in Islamic ethics and jurisprudence promotes justice, harmony, and trust within society. Justice and fairness. Islamic law mandates that all agreements must be based on the principles of justice and fairness. This means that both parties should benefit from the agreement and neither should be exploited. Consent and free will. Agreements must be entered in voluntarily and with full consent from both parties. Coercion, deception, and undue influence are strictly prohibited. Clarity and speciality. Agreements should be clear, unambiguous, and specific in their terms. This helps to prevent misunderstandings and disputes later during the life of the agreement. Honesty and trustworthiness. Islamic law emphasizes the importance of honesty and trustworthiness in all dealings. This includes fulfilling promises, honoring commitments, and avoiding deception. Fulfillment of obligations. Once an agreement is made, both parties are obligated to fulfill their respective obligations. Failure to abide can have serious consequences, both legally and morally. Social stability. Fair and just agreements help to maintain social stability by preventing conflicts and disputes. When people feel that they're being treated fairly, they are less likely to resort to violence or other forms of unlawful behavior to solve disputes. Islam teaches that fulfilling one's obligations, including honoring agreements, they strengthen their relation with Allah. By adhering to the principles of fair and just agreements, individuals can contribute to their own spiritual growth and development. Islam places great emphasis in fostering harmonious relationships among individuals and communities. It encourages the peaceful resolution of disputes and the preservation of ties of kinship and friendship, and also the family relationship. Forgiveness and tolerance. Islam emphasizes the importance of forgiveness and tolerance. It encourages individuals to overlook minor offenses and to strive for reconciliation. If you forgive and overlook, surely Allah is forgiving and merciful. Respect of others' rights. Islam emphasizes the importance of respecting the rights of others. It teaches that every individual has the right to live in peace and security, and that it's wrong to harm or oppress others. Strong family ties. Islam places great importance in strong family ties. It encourages individuals to maintain close relationships with their parents, their siblings, and other relatives. It is believed that strong family bonds are essential for a stable and harmonious society. Okay? So, what is the purpose of that? The purpose of that, when I teach in a Muslim country, one of the things that I like to do is I like to point out what to me is very self-evident. You are not learning a new skill here. None of you are. Basically, what's happened with the ADR renaissance that Pakistan is currently living is that Pakistanis are claiming their birthright. You are entering again into what you have been always called to do, what you have always known to do. As a matter of fact, what you've taught others to do. In 1935, the U.S. Supreme Court made a judgment, and in that judgment, they pinpointed the 18 most influential legal scholars. Anybody want to guess who was on that list? Holy Prophet. The Holy Prophet. His work as a negotiator, his work as a mediator, his work as a peacemaker were highlighted in that judgment. So what we are discussing today is simply you guys going back to your basic roots in adopting everything that is rightfully yours and taking your position in the world stage. ADR will be, beyond a shadow of doubt, one of those things that really gives Pakistan a humongous uplift. If applied, and if people take the time like you're taking today to train themselves and apply it in starting by the judiciary. The challenges the judiciary is facing with backlog, other Western countries faced it as well. And we chose to go and utilize ADR as that solution. And this is something that you can very much easily incorporate into your own structure, legal structure, and make it a part. And what is beautiful about this is that once you have your leadership, your judiciary, your colleagues in the legal field, the litigants and the academics pushing for ADR and educating the people on how this is part of your Islamic teaching, I think you will find that people will be more receptive to make this a part of their mainstream life. And will find it very rewarding, because the reality is that when people have a dispute and they're able to maintain the control of that dispute and reach an agreement that they want to, it's much, much easier. I haven't. I've been litigating for, 2 decades. I've never had a client, even when they're mad, okay? I've never had a client say, oh, goody, tomorrow we're going to court. I understand we as litigants do like it. They tell me I have court and it's a whole entire production for me. I love it. The moment those doors open, the moment I hear the docket call, the moment I see the judge, it's lights on, I'm gone. But it's not like that for my clients. Our clients are nervous. They don't know what to expect. They don't know the outcome. They don't like that they're not in control. And we can give that back to them by incorporating ADR into our practices. And imagine how grateful a client is going to be when you are able to incorporate ADR into your practice and they have control over the outcome of what is going to be the settlement of their dispute. Okay? Before we go again and break into more practices, because we said at the beginning that this is all about practicing, and I want to make sure that everybody gets as much practice as possible, because it's very hard to get you in the same room. So in order to take, yes, sir. Yes.
Is there any concept of pre-litigation ADR in the US?
Yes.
We don't have any such concept.
Yes, we do. But let me tell you something, and I'm so glad you made that question. Yes, we do have pre-litigation ADR, but as litigants, due to the way we litigate in the United States, we prefer ADR when there's been a plaint filed and during the discovery process. And let me explain to you why. In the United States, for those of you who are not trained in US law, we file a plaint and then we have 6 months discovery, with exception of few courts. There are a few minor courts like a magistrate court where you don't have that. At any other court, you have a 6-month discovery process where both parties have to share upon being asked to share discovery material or evidence, okay? We do not like to go to mediation or to ADR prior to that period of time, because during that period of time, we can tell two things: how solid our case is, and what are the bad facts and what are the good facts. So we may enter with a concept that our case is very strong, yet the opposing party may show us their cards, and we may realize that our case was not that strong or is not winnable. Okay, so that can only occur when there's been an exchange of evidence. So while we have a system that will allow it at any moment, and our actual laws say we encourage parties to speak at any time and negotiate at any moment in the process. So that's I'm paraphrasing, but that's kind of the spirit of what the law says. We as practicing attorneys prefer to get to the point where we have done discovery, where we have evidence, because that will also help us to tell our client, I'm very sorry, you thought you really had a very strong case, but look at what the counterpart has presented to us. It is better for us to negotiate. So what happens there is it creates the motivation for negotiation. So that's why we have such a high rate in the United States of negotiating and very low of going to litigation at this point, because of that factor. Because when we go ahead and look at each other's things, we realize, number one, and the other thing is, this is very interesting. This is why this question is fascinating. The judges, okay, so we go ahead, we exchange, and let's say that we decide we're just gonna keep going. The judges are so trained in ADR that they're going to look at you and say, what are you doing here? Why are you here? This case, you can't win this case. Why are you here? Go back to negotiation. So the judges help a lot to go ahead and move the case along, because they say, do you really want to go forward? You want to tell me you made a good effort with this? So the judges really help the parties when the parties become a little bit obstinate, for lack of a better word. So, but it deals at that phase when there's been an exchange of evidence. So it's very effective at that stage. Yes, sir. Okay.
And the Followed by the transfer application.
Followed by the The judge is biased. He won't decide our matter with fairness. So, it's
Oh, wow.
the society you are talking about is, beautiful. It might be beautiful for your concern.
Yeah.
The society we are living. Society, the matters which are brought in our society, they are quite different.
Wow,
They are
wow.
quite different. The main stakeholder, I would aid into all this discussion.
Okay.
The main stakeholder here, by the respected your colleagues and
Yeah.
the lawyers, the attorneys, they are
Yeah.
sitting here. They would agree with me that in our society, this perception that let's go for the negotiation, let's go for the area is not inbuilt, particularly in courts, because normally, I would say in generally, in particular, the cases which are brought in the court are fake, false litigation. On the one hand, we cannot deny this. That is false litigation. Number of the times, you can rate 70 or 85% litigation we are in our docket are amazingly false.
Wow.
What we could do, being judge, at the first day, I do realize that this is not going to do work. This is not going to work. But we have to follow, the what should I use this word? The run of the mill. We have to just go run of the mill. So there are huge complications in implementing EDR in our society. The people who are litigating, they generally come to the court that I have to make the other side, the counterpart, to bend on their knees. Ego-based litigation is there. There is no fairness from the plaintiff. And there is no fairness from the defendant as well. So we are in that kind of situation. We judges, if we say, okay, let's talk about the negotiation, the area. Recently, what happened in Karachi, I must acknowledge this thing. My friends who are posted at Karachi, they are usually sending the matters for code and XE facility for the area. But recently, Karachi Bar Association, the biggest bar association of Pakistan, they have issued a resolution calling for stopping of this sending, referring matters for the area.
I saw it.
Because that is kind of financial murder of the advocates. So first and foremost, we need to educate the general public, and before that, we need to educate our legal fraternity.
That is correct.
To realize what ADR is and what its important is and how it can be beneficial. We judges, we are ready to send every matter for ADR. In fact, in our courts, even though it is not provided, it may not be provided under the law, but we ask the parties, why don't you go for the negotiations? Because in our society, like I would say, the Jirga system is very much inbuilt, and that is quite effective. People normally resolve their issues over there, and they do have kind of faith over there instead of the courts. So we judges are facing this kind of problems. So in that situation, even this day, even today, now going onwards, I am willing to refer my entire docket, legal fraternity, the lawyers. They would say, sir, imagine what we do. If you are going to send all the cases for the area, you are just killing us. You are murdering our
Which
finance.
is really not the case.
So this is the major problem which we need to understand
Absolutely.
while implementing this ADR, this preferred, dispute resolution
Yes,
as been quoted by our DG. So we need to just pinpoint this issue.
That is important. That is a hugely important issue. One of the things that I teach a course that's called What's in It for Me, and it's only for attorneys.
Yes.
And it does a financial analysis of how your practice can actually increment if you make it hybrid.
Yes.
And, you know, like I said when I began this, I'm living proof. I'm standing here. I have a hybrid practice, and we are able to dispose of much more cases, but also we have gotten back time.
My friends would agree that the lawyers mostly, I'm not referring to everyone,
right,
but mostly they come with a commitment with their client that I'm going to win this suit or this case for you.
Right.
At the end of the day, we the judges have to face, you know, the negativity. The judges are not doing their job, so they are not providing us with the justice. Nevertheless, their case was false and frivolous.
Wow.
But indeed, they need the justice.
So I think it's a joint, I see your point, and I totally agree. I think it's a joint effort that it cannot be executed in myopia. It needs to be executed in a very organized manner where you target every single area that's going to be, every stakeholder that's going to be affected.
Must realize his responsibility.
Yeah, that's going to be affected. That's the only way. When we rolled it out in the state of Georgia, we had our big champions were the judges. Those were our first big champions. But after that, we had all the stakeholders involved, and we did a major education campaign. And that helped a lot, but it's not an overnight. It's been, and we had our ups and downs. We also did not get very aggressive. We didn't roll out ADR like all over the place. We did it in batches. And we also became very specialized. So we did civil, and then we did domestic relations. And we had a tremendous success in utilizing ADR for domestic relations. And I see the phenomenon of Pakistan with domestic relation cases. I can see that being very effective to just kind of everybody get people feeling comfortable that ADR can work.
Yes.
But yes, you absolutely. I think that I came here for 2 trips, but I think I'll be here like 10 years. so yes, there is a lot of good work to do.
The first thing the litigant has to face is the counsel.
Yes.
Is the attorney.
Yes.
He is the one who has to advise the litigant which way he has to go, and what law he has to adopt, and what reasons. In fact, the people in Pakistan, they do not give their facts. It is the attorneys, they make the case and narrate the case to the litigant. Okay, we have prepared this matter for you, and you have to just endorse it. This is the problem. This problem cannot be curbed unless the legal fraternity must realize what their responsibilities are towards their litigants and towards the courts. Someone is interested to respond.
Yes, absolutely. Yes, absolutely. Let's get it going. Come on, let's talk about these litigants. Let's talk about it. Where is the yes. Are you a litigant?
I have 2 questions. Number 1.
Oh, you have 2 questions. Good.
Number 1, I am practicing in criminal side.
Yes, sir.
So, question is we can apply in arbitration or ADR in criminal cases. Number 1. Number 2, the honorable honorable judge said that the legal fraternity not supporting the ADR system. Actually, when I was practicing in criminal field, I appeared before the honorable judges, where we requested that we want to reconcile the matter or compromise the matter. But as per judicial policy in Pakistan, judges even denied that you have no other opportunity or you are not urgent the matter for compromise.
Okay.
Well, I can answer this thing with only resolution which is passed by the Karachi Bar Association.
Yeah, and I
just
saw
last
it.
week.
You're absolutely right.
Just
You're
last
talking
week, so I
about
don't
the
have to
September
answer
resolution.
anything.
Yes. The
But
September.
there are actually some factors, external factors of that kind of solution. Well, not specifically talking
Not
about
specifically.
Karachi. I'm not talking specifically about the Karachi resolution, but the question here is, we as lawyers and judges, we are the beneficiaries of this system.
Absolutely.
And
You
the
just
litigants-
nailed it.
Yes. The litigants, general public, the system is meant for this. Before coming to court, they go for the alternative solutions, a kind of jarga or panchayat, and even family elders. Then they go to the religious clerks or scholars. When they fail, then they go to the jarga. And when even they fail, in criminal cases, they go to the police station, and police station mostly to be tried to solve the issue. And the last resort, finding no other solution, they come to the court. So, like the my brother, he was saying, in criminal cases, so in family matters, if we specifically talk about, there is a pre-trial proceeding. That is a kind of edit. Okay, we do not want to go further. Before we get to that, we have to settle it. And the court, the honorable judges, they are empowered to do so. But till then, we haven't seen any serious efforts in making those resolutions.
There you go.
And that is very serious issue because these are family matters and the whole society is based on this matter. So I believe that until and unless we do not educate the general public, although they prefer alternative solutions, so it would be not that easy for us as we have it.
So it's ingrained in the Pakistani culture already. All we have to do, I'm talking like I'm Pakistani. All that has to be done is to expand the knowledge and the understanding and the awareness, and really target a campaign. What I don't want to do is I don't want to forget your question. You had a very good question, which is whether or we can use arbitration or ADR in criminal proceedings. So in the United States, this is what I can give you as an example. We do not use arbitration. What we use in some types of criminal proceedings is mediation, or we can also use plea negotiation. We have incorporated that primarily in juvenile delinquent cases. So minors under the age of 18, because we were trying to ensure as a society that the harm to them was as minimal as possible, and they were able to incorporate themselves as adults into society. We created a very sophisticated ADR with the two arms, mediation and plea negotiation. So yes, we do have it. Now, in Pakistan, because of the Sharia component of Pakistan, you have also here, there have been cases of even mediation being utilized as in cases of murder. So this is really forward thinking, very unique, and super interesting to the rest of the world, because I can guarantee you that the rest of the world is not using it. This is why I'm saying Pakistani legal is so rich. It's just such a shame that it's not being seen on the outside, because that is super innovative. And if we could get to a point that we could actually go, obviously not all murder cases would be qualifiers under US law, but cases perhaps of manslaughter or things like that, that we could get to a point that we could say families have already been ripped apart, we just need to settle this. I think that would be fantastic. So, you know, Pakistan is very, very forward thinking in a lot of ways, and can contribute so much for us in the West to understand. And you have already. because many of the principles that, this is why I teach this module as a second part, so that you guys are like, yeah, this was the same thing you taught us in the morning. Yes, because what? The West took it from Islam. This is no invention. We didn't invent anything. We took it from Islam. Because in our intercultural connections with Islam, we said, ooh, we're going to do this, we're going to do that, we're going to do that. And then we called it soba and batna. And then we called it, fancy words.
Thank you for being so honest.
Did I answer your question?
Your Honor.
Did I answer your question, sir? The criminal attorney, did I answer your question? Did I answer your question about ADR and criminal?
Yes.
Okay, fantastic. Yes.
I would like to add on to that.
Yes.
Currently, criminal cases are being litigated in Pakistan, but only compoundable matters.
Yes.
So
I learned about that.
Illegal dispossession application. We recently had a mediation where a bounce check 489F matter was resolved. Especially 489F matters, if you see, even lawyers negotiated. They tried to reach a settlement outside court before even going to court. I have myself as an attorney as well as an media practitioner been part of these settlements. So in compoundable matters currently outside court, the settlements only, but other than that, there are also mediations that are being held for compoundable matters.
Beautiful, beautiful. Yes.
I want to.
Yes, Your Honor. Tell me.
The whole scenario that is purely relates to the criminal cases.
Yes.
To the extent of Punjab.
Uh-huh.
The one law that was incorporated in the year of 2019, that Punjab ADR Act 2019, that also dealt all these things which is compoundable in nature of the offences list have been incorporated in the ADR Act, and they can resolved by the ADR proceedings. The question raised by the criminal practitioner at the same time, that can be resolved, or even it is mandated different aspects like rent matter, even the possession matters, even the civil property rights can also be resolved by the ADR. But unfortunately, the strict implementation is lacking. That's why we are facing these hurdles. Otherwise, the law is also available to the extent of the Punjab. They are very clearly indicated all the aspects.
Thank you for that. Thank you for that. Anybody else? Yes, sir.
Even if there is any law in criminal cases, so as the judicial system of Pakistan is based on Islamic principles.
Yes.
So in criminal cases specifically, even if there are heinous offenses, Arch, Saman, and Riyah, for the murder that is Riyah, and if someone is wounded, so there is Arch or Saman.
Yes.
So these are the Islamic terminologies. So it can be also implicated, and as my colleague was talking about compoundable offenses, so if even the offenses are not compoundable, even then the parties can go into the alternative solutions or mediation with the
permission of the judge. Yes. Yes.
So I think the judge should have some decision.
There you go.
While the permission of the court is not required for the non-compoundable offenses, because that statute requires the permission of the court to compromise the compoundable offenses.
Okay.
Not the non-compoundable offenses. Yes, there are certain principles of the Honorable Supreme Court and the High Courts of the all provinces that if the parties have compounded the major offense and that was compoundable, then the court should be liberal by allowing the party to enter into the compromise to the extent of the offense which is non-compoundable. So there are certain principles. We cannot say that we should compromise those matters which are non-compoundable, but with the permission of the court that is prohibited by the law. Yes, those are not acceptable.
Okay. Okay. Fantastic. Yes, sir. What happened to Twitter's like? Oh, he's like, oh, you wanted to talk? Okay, I'm so sorry. I'll give it to you right after.
Practically, what is happening in our country, even in non-compoundable offenses, if the parties reach a compromise, then most of the time, synthesis done on activities which are celebrated.
Oh, okay.
This is the indirect way of entering.
There you go. There you go. That's really good. Thank you so much. Yes, sir. You wanted to say one more thing, and then we're going to go to our practices. You guys are not going to question me out of my practice.
You're right. Because this all talk about legislation.
Yes.
It's the job of the legislature. I want to say that, and I want to show that there is not a single transfer application moved by lawyers due to ADR system. We move transfer applications against the judges when they involve in corrupt and corrupt practices. When they involve in corruption, when lawyers move transfer application before higher forum, and that is not the discretion of the lawyer. That case may be transferred from one judge to that again. Higher judiciary, appellate judiciary, that transfer the case from one judge to another. This talk is totally based that lawyers move and transfer application due to alternate dispute resolution method or mechanism. No, never ever single application has been moved from the lawyers till today. If any transfer application moved on the basis of ADR, then show me. There is not a single application.
Sir, I'm not arguing my matter. I'm just referring to the factual controversy against the ADR. I am really interested in ADR, and I invite you all. I have just referred the Bar Association, the Karachi Bar Association, to know.
No. We're going in the wrong direction.
Yes, we are.
We got to get back. It's always interesting where it's interesting because being lawyers, we'll take anything.
Oh, yes.
We'll argue about
Oh,
anything.
yes. Oh, yes.
Yes. Do you have a question related to the class? Yes. Thank you.
I have a question from the previous discussion.
Okay.
That in UK there are 3 action protocols before filing a case.
Okay.
How it works in US? I read somewhere there are some kind of demand letters at E&Es, early mutual evaluations. How it actually works there? They're operated in US. How in US the system works?
Okay, so let me make sure I understand. So the operation of ADR prior?
Okay. There are the action protocols which are mandatory to be followed. You have to go for the negotiation.
Yes, okay, now I understand what you're saying. Okay, yes, we do have that. We have at state level specific legislation in the organic regulations of the court that specifically says something to the effect that the parties have to make a good effort to resolve the matter prior to litigation, and that's what I was talking about in the morning. And you have to have proof. And there are certain specific, in the past, it was like some cases, now it's every case, that you have to have proof that you attempted that in order to move forward to the litigation. And then, but that does not take care of ADR. That simply takes care of negotiations between the parties. And then you have to move to ADR as a second alternative to try to negotiate. So that you must show proof, yes. And many plaints, in many types of plaints, require the showing to the court, or the court will not proceed until you have done it. They will just wait till you do it. Okay? Yes, ma'am. Yes. 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 Yes.
And most of the lawyers have been trained at
Uh-huh.
So now they move to story of
Yeah.
They don't have to understand that mediation is not something that will financially increase their profit.
Exactly.
This is something, it's all about that.
Absolutely.
Reaching out to the people who are the stakeholders.
Yes, absolutely.
We are already working.
That's fantastic. That is fantastic. What needs to be done is that it just needs to be expanded further and make sure that it enters into all the districts in all the other areas of Pakistan. Okay, you're still not getting out of this. So we're going to go ahead and do another role play. So I need 2 more brave participants. 2 more brave participants. Where are my participants? Yes, I have 1 lady. Come on, guys. You got a lady. One of you has to do
I
it.
can volunteer all the time.
No, you
Maybe
cannot
should we speak
volunteer all the
someone
time, Your Honor.
else?
We want somebody else. Yes, Your Honor, you're thinking about it. Yes, look at that. He had a spring in his. Like this. Yes, please. Come on, sit down. Okay. Well, you didn't bring paper. You need paper. Yeah, you need paper. You need paper so I can give you a case. Okay. Okay. Your case. Okay. Both of you are having gatherings in your respective family homes to honor respective aunties. Okay? The auntie's most favorite cake is a pistachio cake that's made in only 1 bakery in all of Islamabad. The bakery closes at 5:30. You both show up at 5:25. I'm special. You get there. There's only 1 cake left. But here is the problem. There is a shortage of pistachios in all of Pakistan. The pistachio crop went down. So there is no way that you can make another pistachio cake. It's irreplaceable, the 1 pistachio cake. Okay? Now, you both have a time limit. You have to get back to the auntie reunion before 7 p.m. Okay? So you have to resolve this issue. You cannot involve the baker. Okay? And neither of you can get the cake, the whole cake. And neither of you can get equal parts of the cake. So you can't get the whole cake and you can't get 50-50. But you must make the aunties happy. Because they're Pakistani aunties. I know.
That is also paternal.
Nobody can, one of you cannot give the other the full cake. Not half.
So they have to leave the cake?
No, you have to find a way. You have to find a way. Okay, that is the same case for everybody. This is much more complicated if you realize.
And what about the closing time is 5:30?
The closing time is 5:30, so the first thing you have to tackle is how do you deal with the fact that you are Pakistani, you have such a sweet culture of getting there 5 minutes before things close. Okay? So that's the first thing you gotta tackle. And then you gotta tackle the aunties. Okay? And how you're gonna satisfy both of them. You can be as creative as you want to. Believe me, I've heard all sorts of things with this example. Okay, so you have actually 20 minutes for this one because it's hard. You have 20 minutes. Okay?
And both of the parties want the same liquid.
Both of the parties, because it's you know those aunties, they want that pistachio cake. Huh? Only one bakery in all Islamabad makes that particular cake, and there is no more cakes.
And there are no pistachios.
Huh?
And there are no pistachios.
No pistachios. That
In
entire
entire
province,
Pakistan.
national disaster, pistachio national disaster.
We can replace with the almond.
I don't know. Yes? I don't know.
Well, let's
Bring all the aunties. The parties name.
replace the aunties.
I don't know. It's your scenario. It's your scenario. You're gonna have to tell me how you're gonna fix it. Any other questions?
Can't we
Okay.
replace aunties with uncles?
No.
All right.
No, that's very creative. No. Because they're easier. No. Okay. You guys, 15 minutes, guys.
Yes. Yes. Most possible. For sure. I think so.
So did we reach an agreement? Yes, yes, let's talk about that agreement.
So, firstly, we had added impacts. We don't eliminate anything, we added
Okay, what did you add? Yeah.
Is it audible now?
Now.
Okay, so we added the number of aunties that we're hosting.
Okay.
Yeah, so he's having 2 aunties, I'm having 3 aunties.
Okay.
And so what we did, the first solution that we came up with was that we will divide the cake into equal pieces of
Okay.
10 pieces, and then we will.
Yes, 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 yes. So we can hear.
Okay, so we decided to cut up the cake into equal pieces of 10 pieces, and the one having 3 aunties will be taking 6 pieces of that cake, and the one having 2 aunties will take 4 pieces of that cake, giving that we're not taking 50-50, we're doing sort of like 60-40 situation.
Okay.
And we also had another solution which we came up with that given the time, we can also have a joint venue and we can have them come to one place and we won't have to divide the cake. We can just take it one place and host the aunties in one place.
Okay.
So yeah, this was the solution for the
Okay, okay. How did you solve the issue with the time? You were there at 5:45 and it closed at 5:50. How did you solve that part?
We were lucky enough that the cake was available at that time we were there.
Okay, so you took 5 minutes to cover that.
Yes.
Wow, that's like super negotiation. That's fantastic. Thank you guys so much. That's super. Anybody else resolve it differently? Yes. How did you resolve it?
I stick to the facts given by the slide.
Okay.
I divide it in a way that one can get the 75%, other person get the 25%, but the one who is getting the 25% gets some other desserts, which would be sponsored by the other party who's getting 75%. So their program will not be messed up and both will be ending in a good situation.
Oh my goodness, that's great. So that one it required out of the box, bringing in something else that could be of interest. Fantastic. Very nicely done. Who else has it?
We actually did have a third proposition as well, a similar one.
Yeah.
We would add pastries into that.
You would add pastries.
Taking lesser one, we can get the pastries and just compensate that accordingly.
Yes.
But we did not
Oh,
agree
sorry.
on that.
Okay. Yes, Your Honor. Tell me.
We need to consider the time.
Okay.
Both the ladies, the aunties, I won't wait for them. Both the ladies arrived there. The first lady, she arrived by. First lady, she arrived by 5:21, and the second one, she arrived by 5:22.
Okay.
So that was recorded in the CCTV camera, and
Can you speak closer to the mic?
Yes.
Can you speak closer to the mic?
So Your Honor pulled the video.
Oh yes, because the aunties are there. The dispute was to be settled between the aunties, and those are from Pakistan.
Okay.
That is the worst situation. And adding someone else into that situation would, create a number of problems for the one who is Salis, who is setting the
Okay. So you determined.
The shopkeeper came up with the resolution. The one who arrived first can take 60, and the one who arrived subsequently can take 40% of the cake.
Wonderful.
To me, that was the reasonable. And they both agreed.
So you use video.
Yes.
I mean, I gotta tell you, these solutions are amazing.
And was older. that could be a scenario that the one who is older in age can get 60 or 80.
That is also a possibility. Here, this is your example. It
Right,
can be as
you
elaborate.
must realize that the pistachio is involved for the ladies. So one can ask, okay, I'm plus 60, so 88%.
There you go. There you go. What other solution? Do you have a different solution? Thank you so much. That's going to be a lot of fun. Anybody have another? Yes.
There's no one will
That's great. You had me. Completely had me. Unbelievable. I'm like, wow, what is the word of wisdom is going to come? That's awesome. I love it. Okay, that's great. That's one way to settle it. Okay, anybody else have another way of settling the dispute? Another way? Great. So it is 2 minutes to 1 o'clock. It is time for lunch. You guys have been so wonderful. Oops. And I just broke the camera. It's so wonderful and so considerate and willing to play along. Thank you so much. We'll see you back. Is it 1 hour you guys have for lunch? Yes, 1 hour. I'll see you please at 2 o'clock because we must get through all modules today. Okay, and finish today so we stay on top. You will have a little tiny bit of homework and not so much, but a little bit so that we can refresh what we saw today and keep going on it for tomorrow, okay? So everybody enjoy your lunch and I'll see you back at 2 o'clock. Thank you. Thank you. I see that most of you are brave enough to come to the afternoon session. That's fantastic. So, do we have any questions from the morning sessions? Anything? Any comments? Okay, so let us begin. Let's do module 3. This is where we get into the actual way of communicating. And we start to hear ourselves how we should communicate better. We do a very fun exercise. My ladies from Fatima Jinnah did that one, and it's a fun exercise, and I hope you guys will enjoy it too, regarding communication, and that shows us that we actually do not communicate as well as we think we do. So we'll get into that in a little bit. So now we're going to do number 1, the art of communication. Number 2, develop the essential communication skills for successful negotiation, which include active listening, questioning, and nonverbal communication. Okay? We're going to learn to identify and leverage your batna. Okay? The art of communication. Humans are born negotiating. Okay? So when a baby is born, for the most part, the baby is born, and the first thing that a nurse or a doctor does is slap that baby on the bottom. Okay? That baby starts to cry. Okay? After that baby starts to cry, the usual process is that they will put it close to the mother, and the mother will immediately try to console that baby. From that moment on, that baby has been programmed to understand that when he cries, he gets what he wants. Okay? Then we go through that period of time where the baby cries, gets food, the baby cries, gets toys, the baby cries, gets a sweat. Okay? Hopefully, all of us in this room have surpassed that time in our lives. But the important thing about it is that we learn the power of communication by that simple exercise of being bored and crying for the first time. Okay? To become a skilled communicator, you must master not only speaking, you must be able to master listening, writing, and reading. All your 4 senses, especially if you are an attorney. There is no one of those that I have just read that you can say as an attorney, well, I can do 3 of those, or I can do 2 of those, and I'll be okay. We are programmed in law schools, or most of us are, that we should be doing all 4 of them in one format or another, and then throughout our career as professionals, we perfect those 4 abilities. Okay? Communication. From the moment a human being opens their eyes, they spend a large bulk of their lives trying to communicate. Some humans take communication a step further, choosing to perfect their oral and written skills in a quest to be better understood by those around them. Therefore, the objectivity of communicating is not just talking. The objectivity of communicating is being understood when you communicate. If you only communicate to hear your own voice, that does not work. You must communicate with a purpose, and that purpose must be to be understood in what you're trying to play. Okay? A need to be understood. Human beings have a burning need to have their feelings validated or positions understood by others. Humans will repeat themselves, use different words, speak different languages, reflex, moderate their tone, use gestures, all in an effort to be understood. Humans value the ability to freely express their wants and their desires. That's why in negotiation, one of the most powerful tools that you can have is the ability as counsel to listen to the other side. If you can go ahead and control your desire to say something and simply let the other side speak, just go like this. The amount of rapport that you will be able to garnish in a short period of time will be unbelievable for you to even imagine how that will gain you sympathy with the other side. Most of the biggest concerns or the biggest challenges or what people complain the most is, I sat in a negotiation and he was looking at his phone or he was writing something else and he wasn't paying attention to what I was trying to say. So if you learn nothing today, but you learn that when somebody is in a negotiation table and it's not you who's speaking, to just keep the eyes glazed on that person, you will have a better chance just by that of reaching a settlement. Okay? Effective versus non-effective. While communication is essential to humans, only communication that's effective achieves goals. Therefore, communicating we must remain cognitive. That's what we're talking about. That it's not only our mouths that are talking, but understand that our tone, our gestures, our eyes, and even our body language also conveys a message. Okay? If you are sitting in the negotiation table and you say, I am here to negotiate, and you do this, your mouth and your actions are not the same. Your body is saying, I'm here because I have no choice. Those judges over there, they issued an order and I have to be here. Okay? Your body and your mouth must say the same thing in order to be successful. Okay? Neutral face. Okay? We in the United States, we call it poker face, but for effects to here where we are, we're going to call it neutral face. Okay? So neutral face is a concept of the intuitive awareness humans develop when they understand that faces and gestures can betray our words. Okay? The idea, what is always given as counsel, as advice, is that once you enter the negotiation room, your face remains without an expression. No matter what they say to you, you have no expression. Good, bad, indifferent, no expression. Because expert negotiators will sit there and read. I will sit there and read every single one of your gestures and be able to tell you exactly what you're thinking. So if I can do it, trust me, somebody else can do it as well. So you're going to be giving up a lot by simply your facial expressions, okay? Active listening. Active listening in negotiations is more than just hearing what the other party says. It's about truly understanding their perspective, making an effort, empathizing with their needs, empathizing, okay? The word empathizing is very different than just feeling sorry or comparing with them. You're not doing that. I'm not asking you to do that. When you empathize, you don't say, oh, I'm so sorry for this that happened to you. When you empathize, you say, oh, I see how that can be hurtful. I I see how that can make you angry. I see your point. You're not siding with that person. You're remaining neutral in your position, especially if you're representing the other side. But you are conveying to them, I can see how that can be something that would affect you in a negative manner. And sometimes that's all a person needs to hear. Another thing is you let them vent. Okay? You let them vent. I told you in the morning, your client shouldn't be saying anything. Nothing. But if the other attorney wants his client to say something, you let them vent. Because they're going to be emotional and they're going to trip up and they're going to say something that you want to listen. Okay? So your client, the rule is your client says absolutely nothing. But if the opposing counsel's client is talking, you're not interrupting. Let them talk. Okay? If you have, I'm going to answer this question before it comes up. How do I communicate with my client during a negotiation if I can't? If my client shouldn't be talking to me and I shouldn't be talking to my client? My system is I utilize a notebook. And I take the notebook and I switch it from side to side. I write on the notebook whatever I have to do and I pass it over to my client. Client writes back and passes it over to me. When I'm doing this exchange and the client is giving me back whatever they're giving me back, I have no reaction. I look down, I read, I continue. No reaction whatsoever. There is no talking between the two of us. Why? Because the other side is listening. If there's something that requires elaboration that goes beyond the notebook passing back and forth, then what I do is I ask for a recess. There's nothing wrong with recess. You ask for a recess for whatever reason. And then you talk with your client outside. The other thing that I do when I get to a negotiation is that I do not immediately go inside the negotiation. I get there probably a half an hour before, and I sit in the lobby. Start looking at my phone and wait. People usually, when they're coming into a negotiation, do not take that into consideration, and they are talking. I have listened to more strategies and more things simply sitting in a foyer or in a hall waiting to go in. Again, you don't say anything. You don't introduce yourself until you go inside the negotiation room. Then they find out yet you were the attorney sitting on the outside. Well, that's too bad. You should have been more cautious when you were talking. Okay? So you want to start developing a series of things that work for you. These are things that I've tried over the years and they work for me and I've been very successful. Some of these things have been also recommended to me by other negotiators. So these are the things that you should start making your arsenal of tricks that you can go ahead and utilize for yourselves. Okay? So it's about truly understanding their perspective, empathizing with their needs, and responding in a way that shows you've been attentive. This is a crucial skill that can significantly improve your negotiation outcomes. Key components: full attention. Give the speaker your undivided attention. Avoid distractions, maintain eye contact, and use nonverbal cues like nodding to show you're engaged. Yeah, I hear you. Yeah, I hear what you're saying. Yeah. Do not allow opposing counsel to interrupt you. This must be the rule of thumb for all of you here. It's very good the judges are very good at that because judges are accustomed to not allowing any sort of lack of decorum in their courts. So they are very good at shushing somebody that interrupts them, and I applaud you for that. That's great. But attorneys sometimes are not, and you will be in a negotiation, and you will be talking, and the attorney interrupts you to say something. Do not allow it. Immediately shut it down. You must not allow that to happen. The way I handle it is very simple. I will lift up my hand like this. And I will say, excuse me. Let me make sure we understand how the drill works here. When you talk, I listen. When I talk, you listen. It's my turn now. I guarantee you that doesn't happen twice. After that one. Okay? Number 2, open-ended questions. Ask open-ended questions that encourage the speaker to elaborate on their points. Okay? These are the cases where the opposing counsel lets their client talk. If the opposing counsel lets their client talk, you should immediately, as a negotiator, move into a strategy called probing. Probing, okay? Probing is when you go ahead and ask specific questions to get information that you otherwise would not have access to, okay? The way you probe is with open-ended questions. So sample open-ended questions are questions that you say why, how, what, because those questions do not require a yes and no answer. You must elaborate. Why is this topic so painful for you? How can we reach an agreement today? What will it take for us to come to a settlement? All open-ended questions that require the elaboration of an answer, okay? Paraphrasing. Restate what you heard in your own words to ensure understanding. This is extremely powerful. This also shows the speaker that you're paying attention and trying to grasp their viewpoint. The way you would paraphrase is as follows. You would say, I want what you have just said. This is typically how I say it. This is what you have just said is so important. I want to make sure that I understand it clearly. I understood that you said yada, yada, yada. But I start by making the caveat that what you said is so important, I want to make sure that I am clear with what you're saying. You're validating what they said. It doesn't matter if it was important or it wasn't important. That's irrelevant. Let's not go into that analysis. It's simply validating what they said and then repeating it back to them so they can actually hear what they said and give them the opportunity to correct it. And sometimes when you just say, okay, if you just say, it's so important what you say, and then they hear and they said something like unbelievably, terribly inconsiderate or rude or something to that effect, they will feel the necessity to correct you. And they will say, no, I'm sorry, you didn't I misspoke, or you didn't understand me, and you go again. Oh, okay, did you say this? Okay? You do this exercise back every time. You can do it with counsel as well. Empathy. Try to see things from the other party's perspective. Empathy is not sympathy. Sympathy is when I say to you, you tell me your father passed away, and I say to you, I am so sorry for your loss. Empathy is when you say to me, this is costing me a lot of trouble. This litigation is costing me a lot of money, and it's been so many years, and I say, I completely understand how that would be distracting, how that would be difficult to handle, how that would be so costly for you. I can see your point. That's all you're saying. Not sympathizing, you're empathizing, okay? Make a genuine effort to understand their motivations, concern, and underlying needs. Never bulldoze. over something, okay? We have some counsel that sometimes say, well, I don't want to humanize this. I don't want to get involved in all the emotional stuff, and they bulldoze. What is that strategy? When you go ahead and somebody says, I am hurting, this is bothering me, this is terrible for me, and you simply trample through and ignore it. Number one, you look like a bull, okay? And number two, you're not garnishing any favors. So you need to step it back and acknowledge it, and then move forward. You don't need to dwell on it, but be sure that you acknowledge it at least. And gentlemen, be very careful with that, because gentlemen are great negotiators, but that is a weak area for a gentleman. And sometimes not so much that you bulldoze because you want to bulldoze, but because you bulldoze because you don't listen, and you need to listen. Okay? In the United States, we say, no one cares how much you know until they know how much you care. Very truthful. People will listen to you if they feel that you are acknowledging how they feel as human beings. You cannot leave the human aspect out of litigation, especially in ADR. It's just not a possible thing to do. Avoid interrupting. Let the speaker finish their thoughts before responding, okay? This is part of active listening. You know, as attorneys, sometimes we come out of law school and we are trained, especially litigators. Litigators are trained that when we're in court, we are listening to keywords because things are happening so fast. So we're listening to keywords and we're preparing our answer, okay? Before that person is done speaking. That technique cannot be used in ADR. It doesn't work. In ADR, you must be listening, actively listening to the whole entire thing, and then you respond. It doesn't work like litigation at all. This is why the transition for those who litigate is so difficult. I have a quick story. So the first time I went to interview to the United Nations, to the U.S. mission for the United Nations. I showed up and they said, you know, do you have, you know, how are you negotiating and your ADR skills? I said, well, you know, they're very good. I am a litigator. That was the empty answer. You know, like in the cartoons when they go like that, oh shit, they push you out. It was something like that happened. Why? Because a litigator is not necessarily a negotiator, and they're not necessarily trained or capable of doing it. So I went back to the drawing board. I went back to the State Department and did a few years in negotiating international treaties. And when I did that and was exposed to that experience, then I understood that how you answer that question. So I was fortunate enough to get a second opportunity, which really doesn't happen, but I did. And in the second opportunity, then I was able to answer the question correctly, because I understood that negotiation was so delicate and so different and so important that I used senses that I was not utilizing as a litigator, and that the rest of it became history. But it is important to understand that those that do engage in active negotiations and active ADR very much understand the difference between the litigators, which we call the bulls of the china shop, and the negotiators that are much more finesse, much more delicate, much more, you know, cautious with their words. Okay? Definition: nonverbal communication is a vital aspect of negotiations, often conveying more information than spoken words. It encompasses all forms of communications that don't involve the use of language. Body language. This includes posture, gestures, facial expressions, and eye contact. You know, a lot of people control every single gesture except for one, their eyes. They'll roll their eyes, okay? Or they'll make a look with their eyes. So be sure that you are keeping your eyes under check as well, okay? For example, leaning forward can signal interest. So I'm in a negotiation and somebody's talking to me. My hands are placed in front of me, okay, not crossed, and I lean forward. I am showing that I am interested in that negotiation versus leaning back and holding my arms where I'm just like listening to you, but it's going over my head, okay? Vocal tone, the pitch, the volume, and speed of your voice can convey emotions and attitudes. You want to stay at this tone. You want to remain. I personally teach at this tone because this is the tone you should have when you're doing negotiations. You want to be as precise and clear as possible. If you're very high up, you can understand what you're saying. If you're talking too fast, you can understand what you're saying. So you want to be cautious about enunciating your words, especially if you are negotiating in a language that is not your first language, okay? Don't allow, the more the things get tense, the way you control a situation in a room when things get tense is that you lower your voice. That reminds you that all chaos can go over there, but you are gonna remain calm. Purposely lower your voice. The other thing that happens when you lower the voice is that the person who's out of control needs to control themselves because they can no longer hear you. So they'll have to also calm down to be able to hear you. And they'll start, I'm sorry, I can't hear you. That will calm them down, okay? Proxemics. The use of space can influence dynamics of a negotiation. Standing too close might make the other party uncomfortable, while standing too far away can create a sense of distance. In this culture, there isn't a reason for men and women that negotiate together to stand in close proximity. However, you always have to think about the fact of the matter that you may be engaging in cross-border transactions. Cross-border transactions, depending on the country, getting within your space can be part of their culture, and you must delineate your space for that. You must be able to say, you know, if you need to, you're in my space. You need to back off. You don't need to be the one backing off. You need to have that person back off. And that's for male and female. There are cultures that even males get too close to males for some reason. And so you want to be able to say, you're too close, you're in my space, I need you to step back. Okay? That controls the negotiation as well, if by any chance the negotiation is standing up. Otherwise, you want to make sure that you have a barrier between you and that other person, okay? Haptics. Touch can be a powerful tool in negotiation, but it should be used with caution, okay? The touch we're talking about is handshakes, okay? Firm handshake can convey confidence, while inappropriate touching can be offensive. I don't think anybody here, we're all attorneys, we understand the difference between proper touching and not proper touching. So we're just talking about the fact of the matter, basically within the culture of Pakistan, men shaking hands with other men, okay? It is important to understand that for the ladies that you need to do whatever is comfortable. And this culture is a culture where women and men do not handshake. You just keep that, and you go internationally and you keep that. And you make it so that you are comfortable. You do not need to adjust or modify something that makes you uncomfortable, okay? And artifacts. These are objects that can communicate information about a person's status, personality, intention. For example, wearing a suit might signal professionalism. So just so you know, in negotiations, when you go to negotiate, it is a standard practice to see negotiators in blue suits. Not black, blue suits. Blue, dark blue is the standard color for negotiation. Apparently, it's a psychological thing, and we all feel like negotiating if we're wearing blue. So you will see us all in dark blue suits, okay? I don't know how effective that is. I just personally like blue. So, you know, I use it because of that. Importance of nonverbal communications. Number 1, reinforces or contradicts verbal messages, okay? Number 2, reveals emotions and attitudes. Number 3, helps build rapport. Okay. Now, before we go to our homework, we have an hour left. We're going to start our exercises, okay? The next exercise that we're going to do is one regarding communication, okay? I'm going to give you a phrase, and you're going to tell me if from the phrase I have given you, you have enough information to go ahead and execute what I'm asking you to do. Okay? You are not to assume anything. Remember, we don't assume. That's for other people, for lawyers. We don't assume. Deal with facts. The second thing that you are to do is that each person that answers must add only one word if they feel that what I said was not clear enough. Cannot add 20 words. One word, one concept. That's all you can do, okay? Until we get to the point that what I have asked to do is clear enough to everybody. Do we understand the rules? Yes? Yes? Yeah. Okay. Now, you gotta write it down because you're gonna be adding. Okay, ready? The phrase is, can you go over there and get me that thing? Can you go over there and get me that thing? I know you guys are looking at what she just said. Can you go over there and get me that thing? Is that clear enough? That gentleman over there is about to pass out. He's like, no. Tell me. You may. Can you go over there and fetch me that thing? Oh, you want to add one word to make it clear. So you're saying that what I said was not clear enough. Is that what I'm understanding? Okay. But what are you going to add to, what word are you going to add to my sentence to make it clearer? What word? What one word can you add? Yes, sir. Can you go over there and get me that small thing? You need to write this down. We're going to be adding to it. Can you go over there and get me that small thing? Is it clear now? Yes or no? Okay. Yes. You have to add to his. Can you go over there and get me that small thing? Now you have to add to his. Can you please go over there and get me that one small thing? Got it. That's enough. Is that enough? One word. Yeah, only one word. Can you please go to market and get me that small thing? That's where we are with this sentence. You gotta write it down because you gotta add it. Can you please go to market and get me that small thing? Okay? Yes. I haven't heard you all day. I was waiting for your question. What are you doing? Can you please go to the market and get me that small thing back? It's coming for round two. Absolutely, sir. It would be my pleasure to allow you to answer. Tell me. Okay, but you just changed my whole sentence. No, you gotta play in the sandbox with everybody else. You have to add to the existing sentence. The existing sentence is, can you please go to the market and give me that thing back? What word are you gonna add to that? Give one more, give somebody else an opportunity. So do you have a word that you can add to that? To clarify. We're trying to clarify. What am I doing? So far, all I know is I'm please going to the market. We're going to the market. So you have to, it's based on your, I can say this. Can you please go to the market and get me that book back? Okay, you want to say that? Okay. Can you please go to the market and get me that book back? Okay? Can you please not go to the market?
Yes.
Okay. There's always a first one, trust me. Okay, so let me make sure I understand. This is like yes, no, maybe so. Okay, so am I going to the market or not? Okay, so please do not go to the market and do not get me the book back. Okay. I'm not going to the market and I'm not getting the book. Okay. How is that clear? Okay. How do we make, so just so we can keep up here, Your Honors, we may have to have an intervention in order of some sort for you guys. Well, I mean, come on. What are you gonna do? What's the thing? You tell me what the thing is, Your Honor. Whatever you choose. It can be anything you choose. Science book. Okay. Please do not go to the market and do not get me the science book. Is that clear now? What science book? Okay. So, what science book? Ninth grade science book. Please do not go to the market. Not take the ninth grade science book. Okay. Oh. Now he's tricky. Because he just opened the trip to the market again. Only a so please do not go to the market in my car to get the ninth grade science book and bring it back immediately. So he just turned it around. Okay, they don't call us income for no reason. So that we can now go to the market again. Okay? So is that clear? Is that clear? Would somebody know? No. Yeah, but yeah.
Go to the market with my red card. Like that, you show me whatever name.
That's great. Yeah, what so do not go to the market in my red car and get the 9th grade science book. Okay? So what are we doing? We're not doing all that. What are we doing? Yeah, we're not, baby. Now I'm confused. Are we going or we're not going? So please do not go to the market in my red vehicle and get the 9th grade science book. Get me a law book. Okay, is that clear? When I'm still not clear because where I'm going. Available law book.
The name of market, name of shop.
Okay. What's the name of the market? Liberty Market. Thank God it's an easy name. So please do not go to the Liberty Market in my red vehicle and get a 9th grade science book. Get a law book. ADR and contracts. Hopefully written by Dr. Judy. Okay, so, yes. Oh my goodness. Okay, but you just changed the entire, you changed the entire sentence. Okay, so we gotta stick to that first sentence because we can't just change the entire sentence. So we have that we can't use the red car. We know that we're going to Market Liberty. So what are we missing in that? What are we missing in that entire sentence? It's amazing. We're lawyers. This is one point, one element. It's always missing in every single class. It's the most amazing thing I've ever seen. So we're all lawyers. Now think about it. Just think about it. Yes. No, you're changing my sentence completely. What is the one element in this sentence that you don't have? Yes.
The thing which is not elaborated.
Huh?
The thing which is not elaborated.
No. What is the one thing that you haven't talked about in this entire sentence? The time is one thing, but even more important than time. Let's say that time wasn't an obstacle. Huh? You're lawyers. What are we supposed to do? What are we supposed to do? How am I going to go and get a book? Yeah, I need money. Yeah. Wait, am I going to steal the book? We have a room full of lawyers and a room full of judges, and they want me to steal the book. Okay, that's great. So yes, we're missing the money portion. Yes, we're missing the money portion. So I know where I'm supposed to go. I know sort of what book I'm supposed to get. I know the one I'm not supposed to get. I know what car I'm not supposed to ride in. But I don't know how I'm going to pay for the book when I get there. Okay? In negotiation, what is price? Essential element, especially in commercial contractual obligations. We need that. Okay? Okay. Let's go on to a next exercise. Okay? I'm going to need 2 more people here up front. 2 more people in the front. Yes, please. Of course. I know you want. Can I get a gentleman? Are you gonna do it? Are you gonna come? And today would be good. Oh, well, you were referencing, well, whichever one of you three wants to do it. One of you three. My goodness gracious. You're pulling straws to see who comes up. Okay. You're at the car dealership. Okay? And you want to purchase, both of you want to purchase a vehicle. Okay? The characteristics of the vehicle that you want to purchase is, let's make it red just because somebody likes red cars. It's red car. You both want a sedan. Okay? The difference is that Ms. Jinnah here can pay $10,000 for her car. And the gentleman can only pay $7,000 for his car. In this scenario, we have a third party, okay? So I need a third person. Yes. You may sit, yeah, whatever is comfortable for you guys right there. Okay, yeah. Fantastic. You are the owner of the car dealership. Okay? And it's the end of the month. You have a quota. You have not met your quota. You need to sell 2 cars, not 1, 2 more cars in order to meet your quota. Because if you don't meet your quota, they're going to close your dealership. The problem you have is you only have 1 red car, 1 sedan, okay? You have other cars. You're a dealership. That's why I was generous and made you a dealership. And now a sole proprietor. You have 1 car, okay, that is red. You also have only 1 car that's a sedan. All your other cars are electric, 2x4s, and pickups, SUVs, hybrids, you name it, okay? You must convince these 2 that they need to not only buy a car for you today, but you must also find a way to either have them pay more or find a car that is equivalent to it. Understand? Yeah, you need to bring them up in price if you don't have a $7,500 car or a $10,000 car, or you need to find and put them in something else. Okay? You need to convince them. Okay? That's the same scenario for all of you. You have 15 minutes to do that. Okay? Questions?
कैफेटेरिया भी ओपन है। नहीं वैसे आपकी भी है ना होगा वो सकते हैं दवा पे
Do we have an answer? Look, you guys look very satisfied. Oh, wow, okay. Where, it's a win-win. I like win-wins. Where's the, mic? Is it working, sir? Yeah, okay. Talk to me. What happened at the car dealership?
Given that I would have faced a lockdown and my business would have to shut down if I was not able to reach the conclusion of this conflict that we're having.
Yeah.
So I had to weigh out my Patna and Vatna as well.
Okay.
So given that I was able to conclude with them and negotiate with them that he will be getting the red sedan and I was able to persuade him for $7,500.
Okay.
He'll be getting the red sedan for $7,500 and he will be getting another car, an electric car which is in maroon color. pretty much similar to her that she wanted, an electric car. And so we have decided on a few terms that I will provide her with an insurance provider of my own who will be giving her a good package. Then I will be giving her maintenance of 1 day that will be free of cost, along with the charger. And she would be paying 10,000 for a car that originally would have costed me 12,000. So I will be giving that car to her for 10,000, and I know I will be going in loss, but I have to do that for a bigger loss that would be shutting down our business. So I brought them to negotiate it.
Good. That's really good. So you made out like a bandit with an electric car and all sorts of.
He received his offer for a year too.
Oh my goodness! You don't like electric cars. Okay, that is great. That's a great way to resolve that, guys. Fantastic, and you took everything into consideration. That was the purpose of why I said it's going to close, and you picked up on that. Okay, fantastic. Who has another scenario? Who has? Yes. Give it to the council. Right. Yes. Okay.
My buyer's preference. With the one, we have to create the whole everything per month.
Okay.
We give a car to 110,000 and we're giving option to other parties. The red, the very next car, the reduction of amount for 3,000 less amount, and they get premium sound system with them. So we can deal with it again IW and book another one and rest of the parties.
Okay, so I want to make sure I understand. So one person paid 10,000 for the car. How much did the other one pay?
Other person paid around 8,000, 7,000 to 8,000.
Oh.
We get reduction on the booking. The very next car is
Oh, okay. Fantastic. That's a good negotiation too. Very good. Very good. Very good. So you took into consideration as well that you would lose your business if you weren't able to.
We are giving them the incentive as a premium sound system with that reduction. So they'll get another kind of incentive.
There's a lot of entrepreneurs here. You realize that. If the profession fails, you can still go into the entrepreneur business. Okay, so so you took into consideration the revenue that you needed to ensure that you maintain your business. Fantastic. Anybody else negotiate? Yes. All of you. Wow, this is an enormous negotiation.
All of us take the
Okay.
that part is quite something.
So the car was priced at 11,000. It's going to be sold for 10,000 to It's going to be sold for 10,000 to Mitzvah. And because he just wants a red car, because that's his daughter's favorite color. So what we're doing is that we're selling him a little cheaper car for 6,000, a Japanese car for 6,000, and we're offering him a complimentary paint job on that car.
So you're selling him because it's not red.
Yeah, it's not a red car.
Oh.
But it's a little cheaper than his the car that he wanted. But we're selling him a paint job with it.
Okay, got you.
It's a complimentary paint job.
There you go. Well, that's one way to do it. Okay, that's very ingenious.
Because red color matters a lot more than the type.
Wow. Okay. Well, that's good. So did you make your what you needed to stay afloat and open? You did. Fantastic. Anybody else? What about my lawyers? My judges. My judges are very quiet. Did you eat too much? They deliberated. I love that. Oh, they sold a couple of cars. Yeah, they sold the whole lot. Okay.
We are good at that.
Yeah, I'm sure you
Somehow.
are. You are. You are.
So, there, 30% we were in a situation that we could not provide them single cars. So we came up with a resolution that we are going to offer the insurance policy free of cost to our, the company which is related with our company. Okay, so we insure their car which is other than the range. So we let them choice with free insurance, number one. Number two, alloy rims. Yes, the alloy rims were also offered at the rate between 7 to 10,000 dollars. So the red car was surrendered by the gentleman in his favor. So he took the red car in order to give her girlfriend.
Because he has to what?
To his girlfriend because he had no option,
I'm not even gonna go there.
Well, he has been there.
Okay.
Oh yes.
Okay.
Oh yes.
Yes. Okay. So
And the other gentleman, he
poor
wanted
gentleman,
to give.
he's all red and he's like,
He already
Well,
mentioned he said,
yes,
I would like to.
I have to gift it to my wife, so with insurance. So the white sedan was sold to them. The company is happy. They are happy. They are happy.
yeah, you are all very happy. Very, very happy.
And they both became owner of sedan. That is wonderful. Except the color variation.
So it's important. Oh, well, that's, so you, okay, so tell
Company
me
is
about,
saved.
but tell me about the company.
Company is saved. Because company wanted the two costs to be sold. And that company was short of their quota of $12,000. He earned $17,500.
Unbelievable.
By this deal. It was kind of customers are happy, the company is happy, the owner is happy, so we are.
There you go.
We are getting kind of
Okay, anybody else have something else that they came up with? Anybody else? Yes? Yes, oh, fantastic. Oh. Please, no more accidents, no more nothing. Look at him, he's preparing. They got, yes, he was. Oh my goodness. Okay, what happened now? What happened now?
In my couple of cars, that car because and is the actual price of the car. But the other one, I will suggest you give a more costly car, but on the rate while you profit therefrom and sell the costly car on lower price which is not some profit and so we can agree that costly car is concession prices. So I think that's way to negotiate
Yes, very good. Very, very good. You notice how interesting how people's mind works. Everybody has Everybody's viewing the same case, but viewing it through different eyes. And you come to all these different conclusions. This is called when like playing chess. Okay, I don't know if there's any chess players here. You're chess players, okay? So what you do, those who play chess, those of us who play chess. So one of the things that we have to do is anticipate the moves of our opponent. And we do that in what we call that exercise in negotiation, is going to the other side of the table. So many of you have been getting out of your seat and going to the other side and looking at the same scenario from the other side. When you look at the scenario from the other side, you're able to anticipate the movements of your opposing counsel or your opponent in the negotiation table. And the way you are solving that is telling me that you are going to the other side and looking at it from every angle possible. So really, really a great exercise. I don't know if you guys, how you guys feel as far as if you feel like you are confident with what you learned today. Do you feel like you have a better grip on what you learned today? We will have homework tonight. It's 2 small cases. It's not a big deal. It should take you no more than 20 minutes to complete it. We will be going over BAFTA, and we will be going over, BAFTA and SOFA tonight to make sure that those concepts are very, very clear in your mind. So that tomorrow we can go ahead and begin the next part of our class, which is the actual much more deeper part of our negotiation, and then go into a very long session of role play and exercises so that you are very secure when you leave tomorrow afternoon in the concepts that you have learned. These concepts you will be able to, somebody was asking me during lunch, can I take these concepts and use them in mediation? Absolutely. You can take the concepts and use them in mediation. They translate very, very well. They asked me also, can I use them in arbitration? Well, arbitration is a little different. Remember that arbitration is very similar to a judicial process where you utilize the system of persuasion. So you're trying to persuade a tribunal panel that your legal theory or position is the correct one that they should rule upon. So it's a little different. So all this technique can transfer best in processes regarding conciliation, bargaining, or ultimately where we're trying to get you to go, which is mediation. Okay? So do we have any questions at this time? Any questions? I'm going to let you guys go 15 minutes before your time. I know everybody's tired, and I want you guys to rest because tomorrow will be a long day as well. And I want to thank you. I don't know if any of you have any questions, any comments, additional comments, anything for me before you leave? If you don't, thank you so much. I appreciate all of you very much. I appreciate that you're such sports. Thank you. I hope to see all of you tomorrow. And really appreciate you taking part in this session. Thank you. Drive safely if you have to drive. Remain well, remain blessed, and we'll see you tomorrow. Take care.
सीनियर फिलोलॉजिस्ट जो ये नहीं है ग्रुप में हमारे एफजे का ग्रुप है, आज नया ग्रुप बनाया है आपके कोर्स के लिए, तो हम सीआर चुन लें, उसको सारे नंबर दे दें और मुझे सब। दूसरा, अभी आपको एक मैंने आपके उसी ऑफिशियल ग्रुप में जो होमवर्क मैडम ने दिया है वो मैंने आपके साथ शेयर कर दिया है, और आप लोगों के साथ मैडम फाइबर शेयर कर दी। होमवर्क में 2 आपके सिनेरियोज हैं जिसको आपने, तो आप लोग मुझे अभी अपने नंबर भेज दें ताकि हम काफी कॉरेस्पॉन्डेंस होती है, मुझे आपको पता नहीं।